Boom. Okay, I seem to have this open somewhere. That's going to be a problem. 1 second. All right, we're going to fix that so that we don't have an echo. Let's see. Or at least, there we go. I was like, why am I got an echo? Right, that's my fault. Okay, so little bit of a wrinkle here, just getting started, but hopefully we'll be okay. Now, hopefully people can still hear me. We'll just we'll just go. Oh, somebody's saying miss the boom because of ads should not be on. Give me a second. Give me a second. Ads should not be on. Why are ads on? I don't put ads on. No, ads off. There we go. All right. Yeah, I don't usually do ads during the stream, and so I don't know why the ad was on, but it was on, and now I have turned it off. The joys of all of this. So, yeah. Okay, so, and now my camera's doing weird things. This is all lovely. Okay, we'll just kill that. Maybe that'll help. Hangs. So hopefully it's not hanging anymore. We should have that fixed. Sent you an email about Extra Life donation. Shoot me another email because it may have gone to spam and it may have been cleared out. But we will we'll get that going. Okay. Today's been a chaotic day. I had to do a whole bunch of legal chaos, and also during my lunch break had a fun moment. I ended up calling the police. That is not something I do a whole lot of, but so the calling the police story is kind of entertaining. So I went to the post office as background here, and I went to pick up a package, and the package is full of mystery items that, okay, they were rifles. So I get home, and there's a neighbor near me who her property, she's got like a sea can on her property, and the sea can has been broken into in the past. So I see some guys, and they look kind of sketchy overall. They've got a rental trailer. They don't have any sort of branding. They look kind of sketchy. And so I went and was like, okay, are they broken in? Is she being broken into again? Okay, people are asking, what is a sea can? Sea can is SEA can. It's not sea can, it's sea, like ocean can. It's a shipping container. They're the containers that go on ships that are designed to stack on each other, and, you know, for that. So, sea can. They're quite commonly used for storage and various other things, and yeah. So I'm sitting there and I'm like, is she being broken into again? And are they being broken into by somebody who is much more like well prepared to like clean this out? So I was like, okay. So I called the police and I was like, I don't know for certain if this is legit versus like maybe she's clearing this thing out, or maybe she is getting robbed. Because the owner of that sea can is this old woman who's got some serious health conditions. So she, like, you know, yeah. So the police, like the dispatcher is like, yep, we're rolling out an officer. They are on their way. Yep. And then I realized that I am in the middle of unpacking guns into a safe, and I'm because the dispatcher's like, oh, and the officers will come say hi, and I'm like, I have got to get these guns into the safe right away. So I'm hustling to get these guns into the safe because I'm like, this is going to be real awkward if the police show up while I've got like a rifle in my hand. So I managed to get the rifles into the thing before the police roll up. And then it turns out to be nothing, which is good because the police get there, they spoke to the people, and the property owner was there. I didn't know she was there. But she advised the police, like, look, I've been broken into a lot. I hired these guys to move my shit out of here. So, and the officer's like, yep, everything's good. Everything's fine. But, thank you for calling us because we'd really prefer you call rather than not. She was really happy about that. So, yay. So, yeah, that was my day today. And I had a question here. Cheers to my favorite Canadian lawyer. Any BAM updates? So we do have a Bricks and Minifigs update because they just posted another post on their webpage today. And Twitter is going off on this, saying that this is such a huge update and we're going to talk about why it's not actually a big update. Because it isn't really a big update, and it's just them trying to massage things. So, yeah. Runkle, what about the package story? The package story is that I got the package, and the package was guns. So, yeah. All right, we'll cover the other super chats before we dive in. We can start with the Bricks and Minifigs thing. That's a decent start. Honk Banana No. Runkle best not be late. I turned off Jeopardy for this. Marielle says, evening Runkle, was listening to some of your old videos, background noise at work, and was curious. Did you ever request the wild motion to intervene from the Daybell trial? I didn't. Maybe I should go back and do that. Honk Banana No, thank you for the 10 gifted memberships. Much appreciated. And Josh Glover, hey Runkle, tip on some lighter content. Have a look at Flux AI suing Adafruit over a security bug disclosure and Flux's usage shenanigans. I will try to look into that. Okay, we need a goal for grifting, and the goal is going to be, I think, so I've got the ads turned off, but I need to go back so that I can actually pull this up. I think the goal will be open a beer. I started with a drink. This drink is a bit of a drink experiment. So while I was in Chicago, I managed to get a beverage that you just cannot get anywhere in Canada. Like nowhere in Canada carries it. It's called Suze, S-U-Z-E. And it is a very, very bitter liqueur. So it's actually quite pleasant if you like bitter stuff, which I do. But I made a Suze sour. You can see it's actually got a really lovely yellow color to it. Camera, zoom. It is lemon and Suze and sugar and egg. So it's quite lovely, actually. I could drink these. Now, Mrs. Runkle would not like this. Most people would not like this. I like this because my tastes are weird. So all right. So let's start off with the Bricks and Minifigs thing. Because the Bricks and Minifigs thing, the internet has been going wild about this. And so the internet seems to think that this is a really big change, is what's been going around on Twitter. Somebody posted that this was a big, thing, and then that's been retweeted. And I don't think it's really a big deal. I think that this is kind of, I actually think that this kind of shows that Bricks and Minifigs are kind of being dicks still. So here's their PR statement. And the first thing I will note, Bricks and Minifigs, you should hire somebody to do your PR who isn't a numpty, because your PR person is an absolute idiot. To start with, you really, really need to change the name of the account that posts here, because marketing team is an absolute idiotic account name for this. Like, come on, guys. This is not, this is not training wheels time. You got to be getting your shit together. So, the other thing here is Bricks and Minifigs, an authorized Lego reseller specializing in buying, trading, and selling Lego products, today reaffirmed its commitment to assist in resolving the private disputes surrounding a customer's Lego collection. Now, reaffirmed is the right term here, because they're not actually giving us anything new. They are reaffirming their previous position. Like, this is just a rehash of what they offered before. And yeah. So they say, subject to its ongoing investigation, Bricks and Minifigs believes and alleges the following facts, among others, may be relevant to claims made in recent weeks. Why the fuck are you using the language of believes and alleges in your own PR message? Like, guys, come on. All right. So the Mansell family collection. Ed Mansell built the collection at the center of the issue. When the family decided to sell it, Ed's son, Brian Mansell, who was apparently new to the Lego resale world, visited the now closed Salem Bricks and Minifig store around September 2023 and asked its former owner, Crystal Law Gorman, for help. Bricks and Minifigs investigation found documentation estimating the realistic highest retail value at approximately $95,000 to $100,000. That estimate seems to align with Brian Mansell's public statements on an April 2025 Collecting Weekly podcast, and with the roughly $80,000 in products or cash he allegedly sought when he is believed to have visited the store around November 21st, 2024. Why the fuck are they arguing this shit in public? Like, this is the wrong place to be arguing this, because right now they're like, we believe and allege that this is only worth half of the $200,000. And right now, $100,000 is play money compared to the PR damage that they've got here. So quite honestly, they should not be having this discussion in public. They should not be having this discussion as an open statement. What they should be saying is, maybe if they make a statement, they're like, we are committed to making things right for Mr. Mansell, and we will continue to have an ongoing discussion with Mr. Mansell. Cool. That's a much better statement. Next thing you do is you reach out to Mr. Mansell through his lawyer. He's got a lawyer. And to his lawyer, as part of confidential settlement negotiations, you say, look, we know the pack, we know it's worth $100,000. You know it was worth $100,000. We'll give you the $200,000 though. And all we want is for you to go away. All we want is for you to not be an issue here. So we're going to just write you a check for the $200,000 and off you go, right? And, We want you to be happy. And because the thing is they're going to spend more than that on lawyers dealing with this. So just like pay the man. This isn't about whether or not it's right or wrong. It's about pay the man. Because this is just good sense. Yeah. Also, everyone actually involved agrees the actual value was around 100,000. The 200,000 was an advertising number. I would give him the 200,000, telling him, "Look, we know it's worth 100,000. I know it's worth 100,000. You know it's worth 100,000. But we'll give you the 200, and then we just want you to walk away. Like that's it. You just." And what I would probably ask for as part of the 200,000 is to say, we want a non-disparagement clause, for mutual non-disparagement clause. We, as Bricks and Minifigs, will not say anything shitty about you, Brian Mansell. You are also not allowed to say anything shitty about us. And I'm betting $100,000 of extra stuff would probably have Mr. Mansell going, yeah, okay, that sounds bad, or that sounds like I can do that. That's not a bad deal. I mean, throw in another 50,000 if you feel like it, right? But don't litigate this shit in public because it just looks bad. So Bricks and Minifigs investigation also found point of sale data showing about 61,000 and potentially more may have been sold from the collection prior to November 1st or 14th, 2024. The company believes Brian Mansell may have only received approximately 15,000 in payments over roughly a year. The records suggest a discrepancy may exist between what was sold and paid to him, which the company is still investigating. Okay, so just say we think that Brian Mansell was ripped off by a previous franchise owner. I'm not saying he was. I'm saying that's what Bricks and Minifigs' position is. So just say look, because it's got the Bricks and Minifigs logo on it, we're gonna make it right. When the new owners, Brandon Best and Josh Johnson, took over the Salem location, they discovered in the store only a small number of Star Wars products, with an estimated at-cost value between $2,000 and $5,000. The company's investigation suggests most of the remaining collection may have been sold or removed and stored off-site before Best and Johnson took over the location. I mean, somebody U-hauled that shit out of there, right? This information appears to be consistent with Brian Mansell's acknowledgement in joint social media posts with the Salem store and on the same April 2025 Collecting Weekly podcast that his sets were moved to an off-site secure location. This is exactly the same shit they've been saying all the time. And, guys, this isn't working for you. When it's not working, the answer is not to do it harder. It's to do something smarter. And here they're just you're just repeating your position over and over and over again. And I'm not seeing it. So the company has also repeated its good faith offer to make the Mansell family whole monetarily for anything fairly demonstrated to be unaccounted for, including amounts that may be owed to him without his knowledge. This is the wrong strategy. Not, we need stuff to be documented as unaccounted for. It's just, we are picking a number that is definitely more than what he's owed so that nobody can complain. We're just going to give him a bunch of money is the correct answer here, right? Notably, in an apparent statement to Kaiser Oregon Police, Brian Mansell is believed to have confirmed he received part of the collection back from Law Gorman in January 2025. This included hundreds of items being returned, including high-value items like Star Wars Cloud City sets. Okay. Don't care. Just write him a big ass check to make this problem. So basically what is going on here is that Bricks and Minifigs is like, look, we got stabbed and we are not going to do anything about this until we figure out exactly who stabbed us and how they stabbed us. And it's like, no, you don't need to worry about this particulars. Right now, you need to worry about the fact that you have a great big hole in your chest that is leaking blood. And after that, you can worry about all of this shit, right? Right now, you should be worrying about the PR catastrophe that you have and stop the bleeding. Is it fair? I mean, if your version of things is correct, Bricks and Minifigs, this is not fair. But it doesn't freaking matter if it's fair or not. All that matters here is you gotta stop. Like, you gotta make this stop. We understand why this story has stirred so much emotion. We don't take that lightly, said Bricks and Minifigs CEO Emmett McNeff. No, you don't understand it, because if you understood it, you would be trying to fix this regardless. We also want to reinforce that this is an isolated, unfortunate incident related to a single franchisee who did not obtain an approval for any consignment arrangement. It does not undermine the integrity of our more than 300 other independent and unrelated franchisees. Our goal has never changed. Help make this family whole, enhance operational processes, and build a company our franchisees and customers can be proud of for years to come. I actually feel like they might be opening up a potential second avenue of litigation. And the second avenue of litigation here is that the law Gormans might decide whether or not they want to bring a defamation suit. Because having read that the franchise agreement mentions consignments. So when they say it's an unauthorized consignment, I don't know if that's true. The law Gormans would know that better than I do, and they might have to sit and do some investigation and think about it, because there is a very real possibility that, it's so I don't know if they're helping, because at the end of the day, they really, So I just, I don't know. We will see. Is it defamation per se? I don't. It's getting close. And 16 minutes left for the goal. Yes. All right. Unauthorized consignment arrangement. So they've got this again. We're not going to go through all of it word for word, because they're just repeating the whole thing of, we don't allow consignments, notwithstanding that our franchise agreement specifically mentions consignments repeatedly. So, Operational reforms to strengthen the company and franchisees. I mean, if I was a franchisee, I would really want to just, I would be considering seriously whether this is a good relationship for me. But so rigorous record keeping and inventory management. The company mandates real-time digital tracking from the moment a collection enters the store, creating a permanent record to protect customers and franchisees. I'm kind of surprised they didn't have that already, but yeah. Absolute transparency in the buy-sell trade process. Every transaction, especially large-scale trades, requires standardized, corporate-approved disclosure forms. Off-the-books side deals and local consignment arrangements remain strictly prohibited. Mandatory professional behavior and de-escalation training. Comprehensive training for corporate staff, franchise owners, and their teams covers professional boundaries, dispute handling, and proper corporate protocols. So that's talking about how bad it looked when Brian Mansell went in there and was it didn't really go well when he was going in going, hey, where's my money? So, yeah. About bricks and minifigs, they say, we are awesome. That is in dispute. Frequently asked question, does the bricks and minifigs business model include the type of third-party consignment in the Mansell family dispute? They say, no, that is also in dispute. Was Bricks and Minifigs corporate a party to the consignment arrangement at the Salem store? And they're like, no, it's not our fault. Doesn't fucking matter. And yeah, this is an excellent point. So BAM is great at de-escalation, huh? Yeah, we're providing mandatory de-escalation training from the people who are putting out PR statements that are escalating the problem. This is not de-escalation, guys. Oh, why do you suck so bad, Bricks and Minifigs? What is the realistic value of the Mansell collection? So they say 100,000. Where did the 200,000 figure come from? They say, we believe it was never a confirmed or appraised value. It was a promotional amount used to generate excitement for a public display event held in November 2023, which Ed Mansell attended. I kind of feel this is also not great because saying it's a promotional thing, I mean, is that not kind of fraudulent? Like, this feels fraudulent. Because, like, let's imagine that I say, come to my store and you can see a diamond that is worth $1 million. And people are like, ooh, I want to come see the diamond that's worth $1 million. Well, if that's not true, like, that's a problem. So this promotional amount thing, I'm not super thrilled by this, right? So, especially because they're then going to try to sell it, right? What is the company's resolution offer to Brian Mansell today? So, Bricks and Minifigs representatives have expressed its interest that he be made whole monetarily for anything fairly demonstrated to be unaccounted for. The company is also willing to give him every Star Wars Lego item remaining from the Salem store, whether identified as his or not. I mean, they should be doing that anyway. Just do that, right? Just do it. Like, don't do a thing where you're like, hey, we're going to do this. Like, just do it. And then you can say, we already did this. Like, just send it to his lawyers. What is the company doing to help prevent similar situations from occurring? Going out of business is what they're doing. They just don't know it yet. Why did the Salem store close? It closed temporarily because staff, including local teenagers, stopped using the teenagers as human shields, dudes. Like, that is kind of gross. Face safety hazards, targeted in-person stalking, and explicit threats believed to have been driven by inaccurate reporting and/or social media communications and videos. It was not closed due to losing any lawsuits related to this matter, despite claims otherwise. It has since been permanently closed with a formal separation and resignation by Brandon Best and Joshua Johnson. Okay. Yeah, this is my point. Stop offering to give the Legos back and just give them back, right? Just give them back. That is the better way to do it. So, yeah. What kinds of harassment have Bricks and Minifig stores and employees experienced? Guys, I'm just going to tell you, Bricks and Minifigs, right now, I'm going to tell you this for free. Just like, pass this along to your PR team. You are not going to spin the sympathy angle on this over to your side. Like, you're just not going to get people to be like, Oh, bricks and minifigs are the real victims here. just 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 stop. Like, it's not helping. Not like, until they solve the whole problem of Brian Mansell being out, this is really not helping. What is the company's position on this conduct? Bricks and Minifigs supports every person's right to free speech and fair questions, but unlawful conduct such as harassment, stalking, threats, etc., is neither advocacy, normal, nor consumer protection. The company's stores are private, small businesses with the right to conduct business safely and to protect their premises and employees. Okay, so people are on Twitter are like, this is such a big announcement. Bricks and minifigs, they already said all of these things, and there is absolutely nothing new here. There's just nothing. This it To the extent there's anything new, it's bricks and minifigs just digging. And like, come on, guys. Come on. All right. So now that we've sort of looked at that, let's cover super chats. I know that they're a bit what is it? We've got a goal. The goal is still ongoing, but we'll keep from getting too buried here. CC Mills, thank you for being a member. Much appreciated. Brentwood Chic, thank you so much. Beer. Vez from Quebec. Oh, I think you'll not like my cooking. Bring your hot sauce. I will bring my hot sauce. Honk Banana, no dickhead idea, but if you're able to turn off ads after the stream start, what if that was the first goal? Maybe. Vomit Fountain, a beer is a worthy goal. Enjoy. I also kind of hoped I would have an announcement for today. I don't have an announcement yet. And so I'm really hoping that I'll have that squared away for soon. But I don't know. We'll have to see. The other thing, I don't know if I will have a... I don't know if there'll be a Monday stream. I don't know if there's going to be a Monday stream next week. But there should be something fun. I'm going to see if I can do a Monday stream. If I can, it should be a lot of fun. And yeah. So Michigan Farm Boy says the Salem is closed. There's no sets there, and BAM or their franchisees have the records to identify the sets remaining not sold. PR offer only. They should be offering a whole pile of cash. Do you still have your Lego R2-D2? Lol, I do. So I'm going to try to reach out to the Mansells, because I might ask them if they will sign this for the whatchamacallit, the Extra Life fundraiser. I bet that would be pretty entertaining if they were willing to do that. So I'll have to check if they've got counsel. But somebody says, where does one sign a Lego? On the box. They'd sign the box. Unless somebody wanted me to assemble it and then have them sign the actual thing. But yeah. What is it? As the original gifter of the Lego R2-D2, I fully support that idea. Awesome. So we will have to see that. And yeah. I'll reach out to their lawyer and say, hey, are you guys willing to do that? Because That might be cool. Have Ben sign it too. I will try. I will try to reach out to Ben's counsel and say, hey, would Reckless Ben be willing to sign this? And because I bet that could raise a whole pile of money. So, all right. Where are we at here? Oh, there's another thing here for the goal. Thank you so much. All right. If we'll have to see if we make this goal or not, because we have 3 minutes and 4 chats left. All right. So let's jump over. I hope I've got the audio right. So for my trip to Seattle, any info I can give yet? Not yet. If I can do a meetup there, it's going to be real last minute. I got to figure things out because I've got a plane and then another plane, and I got to figure out if there's enough time between plane 1 and plane 2 to like hang out with people. And if there is, yay, we'll hang out. And if there isn't, then such is life. So that sounds like a heck of a lot of shipping to get completed. Just saying. You're not wrong, but yeah. All right. So let us pull up this. So today we had today there was a pretrial, and a lot of the pretrial is before the court comes in. So all right. Let's wait until we've actually got court. Remember, there's a long time before the actual court stuff. The guy on the left is Dick Poot. Literally Dick Poot. He goes by Dick. His last name is Harpootlian, and people call him Poot. So he's got the nickname of Poot, and Dick Poot is a hell of a term because yeah. And we have hit the goal, so we're going to crack open a beer. The beer of choice at the moment is Modelo, which is, how do I describe Modelo? So the Modelo Especial is like Corona if Corona was good. I'm going to get some hate mail for that. I am absolutely going to get some hate mail over the like Corona if Corona was good. Because there are some people who seriously like Corona, and they get angry about it.
Please be seated. I see we have a full house. Good morning. For those of you who've never been to Lexington County, welcome to the Lexington.
How's the audio? Are you guys able to hear it? I think we need more volume. So let's juice the volume a little bit here because I think we could use some. And we're going to go to there. And you're not wrong. Corona gives Mexico a bad name. Yeah, it really does. So here we go.
Lexington County Courthouse. Please.
So I kind of like how the judge starts off here, where the judge is like, a lot of people here, a lot of new faces. Welcome to our courthouse. She's just like, she's having fun of it. So yeah. Did I ever have a Peroni? No, I've never had a Peroni. I might have to pick one up.
Are you ready to call it? Give it right back to me. All right, we're here for a status conference. I'm going to get the clerk to call the case, please.
in the matter of State of South Carolina versus Richard Alexander Murdaugh, indictment number 2022 GS 15 00592 through 595.
Thank you. All right, Mr. Waters, how are you?
Good morning, Your Honor. Good to see you.
Good to see you. Now, let me ask you, I know some of your counsel at the table, but I don't know all of them. Can you please just let me know who the state's team is?
So I have David Fernandez, Assistant Deputy Attorney General David Fernandez. He's my number 2 in the state grand jury section. I have my boss, Mr. Don Zelenka.
I know.
We have John
End of
Letters
September.
as well.
I
Would
know
be the
Mr.
deadline, I think.
Mathers.
And then, you may see at various times, we have Assistant Attorney General Walt Whitmire, Senior Assistant Deputy Attorney General Melody Brown.
All right, welcome.
Can I just note how unusual that part was? I know nobody was paying attention, but he just noted that they have like 6 prosecutors on this file. That's really strange to have like 6. Because, I mean, here, we recently had a trial that was like a multiple murder. And it was a really big deal because they had 3 prosecutors on it. And 3 was a lot. And one of them was a training, like a prosecutor in training. So, but here they got a lot of gray hair and they got a lot of, so, yeah.
Let me, Mr. Harpootlian, can you tell me, I think I know just about everybody at your table, maybe not everybody, but can you introduce the defense?
Please report, Your Honor. This is Jim Griffin,
Mr. Griffin,
Bill Barber.
Mr. Barber, good to have you. Okay. All right. I've made some notes on a status conference, and I'll let y'all talk in just a little bit. But I want to go over what I want to go over. Because I want to make sure that all...
I like this judge. This judge is like, I'm going to let you talk in a minute, but not until I'm done. Judge is just, she's fun.
The discovery in this case is complete. And I made some notes, and let me tell y'all, I don't know anything about the first trial, so when you tell me something, please be complete when you tell me, because don't assume that I know, because I don't. I want to know about phone records.
She's like, I do not give a shit about what happened before. You guys are starting over. Okay, cool.
Do we have all the phone records, and are they complete? Text messages, cell phone extractions, and if there's any supplemental extractions, video recordings, whether there's ballistic firearms, are we complete in that? Fingerprints, toxicology. I think there was a blood splatter expert last time. I just want to know where we are with these discovery items. I'll let the state address that, please.
Yes, ma'am, Your Honor. So we have provided, and obviously provided well in advance of the first trial, a very extensive discovery. I'm not aware of anything in the items that you mentioned that have not been provided to the defense. And if anything, the defense has more than the state does, because a very heavy privilege review was done, for example, on Murdaugh's phone, and formerly being an attorney and that sort of thing. So it's my understanding complete extractions were provided to them, whereas the prosecution team, the investigative team, only received the privilege review some of the extractions as it relates to this phone. And that's
He's like, they got even more than we do, Judge. Is there captions? Yes, that's a great idea. We can turn captions on.
As always, we are constantly auditing and looking at everything, but I'm not aware of any discovery from the very extensive productions that were made. not only from just the murder investigations, but also from the extensive state security investigations as well. So he has provided those. And, obviously, I'm not aware of anything in the categories that you mentioned that are not provided to you.
And not anything that needs to be reanalyzed or anything that the court would be waiting on?
At this time, no. Now, as you're aware, and we
At this time is doing a lot of heavy lifting because they tend to discover stuff as they go.
of course sent our responses to everyone last night to the defense motions that were filed late last week. Came in the office Sunday to write those. One of those is their request for independent testing on DNA. So we put it in our motion, and I actually got an email from Mr. Griffin this morning that if they want to have their defense expert reach out to SLED as to specifically what capabilities they think they have and what they're proposed to do, happy to facilitate those conversations and discuss those with the defense and then with your honor if necessary. Right now, that's kind of where we stand on that. And of course, any other issues that arise along those lines, we're very reasonable and we're perfectly willing to discuss those with the defense. And if there's something that we can't agree on, obviously we'll raise those to the court.
Okay. All right, Mr. Harpootlian or Mr. Griffin?
I want to address everything but the DNA.
Right, I'll talk about the DNA later.
So we don't know what we don't know. And I'll give you an example.
So one of the things about Dick Poot as a human is that Dick Poot is so people have said that I can turn a 5-minute story into a 10-minute story. Dick Poot can turn a 5-minute story into like a 30-minute epic. When he was at the Court of Appeal, he had a brief introduction, and the brief introduction was like 20 minutes. It's like, dude, you're on the clock. You're on the clock. What the hell? And somebody was asking, Afro Man's lawyer looks so much like a Middle-earth dwarf. I would love to hang out with Afro Man's lawyer and do the elf dwarf thing.
And this up to your honor and hand copies
Poot also is known for picking up a gun in court and pointing it at the prosecutor and saying tempting, which if it was Judge Runkle and you pulled that shit in my courtroom, like picking up a gun, pointing it at opposing counsel and saying tempting, I could tell you how that would go. I'd just be like, Sheriff, arrest him, please. Sir, you're going to need new counsel. Was it the other way around? No, I thought it was Poot that pointed the gun. Oh, it's been a long time.
Your Honor, this is a transcript of an interview done with a guy named Chapman and another officer who were folks that arrived on the scene to begin with, processed the scene, and were very involved in forensics of processing the scene. And if you go to page 6.
Okay, people are saying it definitely was.
Chapman, who's in charge of the scene, says this. This is a television interview on March 13th, 10 days after the verdict in this case. He says, in response to the question, I believe he had some help in the aftermath. Or Rutland, yes. That's from Chapman. You know, the disposal of weapons, the moving around a vehicle. We heard so much about Sweat and AG's office, they don't have anything. It's all circumstantial. So I pose this question to you. It was a clean crime scene, staged crime scene, clean crime scene. We'd expect to find more evidence or less. And that's what's kind of hard to get people to understand is we didn't find a lot. But why we didn't find a lot? Because it was clean. I mean, it was manipulated. There's evidence removed from the scene. Now, this is 10 days after the trial. This is not what Chapman testified to. And if Chapman has evidence, there were other people at the scene, that he had assistance under their theory, or there were other people there, we need to have that furnished to us. And we have other witnesses that testified at trial who are saying something totally different, indicating there's evidence to believe that somebody else was at the scene or there were other people at the scene. I mean, this guy's the chief guy in charge of the scene along with Rutland to process it that night. We need, and we're in the process of doing this to determine if they or the reports. So we don't know what we don't know. We don't know what we don't have. We need some period of time to try to process that. And Your Honor, I say this.
Oh, Christ. I mean, he's got a good point here. The problem is that the good point can be expressed in just like 2 sentences. What you can say is, Your Honor, you want a timeline from us, but we don't know what we don't know, and therefore we can't give you a timeline because we don't know what things will come up. We're the defense. We don't have any of this stuff. We'll have to figure this out. Yes, I'm planning to do a CCFR video breakdown when we can. So that is coming. So.
And no emphasis on trying to, we're not alleging that the state has hidden anything from us. We do know there were people that came to see us that said they had important information. We have no ability to investigate them. We don't have subpoenas, we don't have grand jury, we don't have search warrants. And 2 or 3 of those people we sent to SWED. Did they follow up? One had extraordinary evidence about a tie-in between Paul's murder and the murder of a young man named Stephen Smith. But we had no, I can't compel anybody to come anywhere. We sent that to SWED. Did they investigate? Have they investigated? And I must tell you, there are a lot of pieces of information out there that, and maybe they just stopped once they got the conviction, didn't do anything else, that it's inconsistent with our desire to get a conviction, or have a conviction held. So they didn't follow it up. Maybe it does need to be followed up, but we're going to have to go back and look at all of that. We're going to have to determine whether or not additional material developed since the trial. And of course, all of us were shocked by the court's conduct in the trial.
Okay, like, you don't need to relit it. I feel like Poot, like, here's the problem with getting a big win on a case like this. Poot got a big win with the court clerk. The problem is that he got his big win, and now he wants to live in that win. He wants to ride that win as long as he can. It's like, dude, that shit's over now. That's done, at least for the purposes of, like, the judge doesn't care about the clerk anymore. So stop bringing it up.
Where I know the state was. But it's caused us to go back and look at, and we haven't done a thorough check of it, all the testimony, and read it all, not in the sense of an appeal, which we've done, but in the sense of, I mean, in criminal cases, we don't have depositions. We don't have them here. We have a transcript of every, but not every, I'm sure they're going to get rid of some of these witnesses who are horrible, for example, and get additional witnesses. But most of the witnesses, we have their transcript, their deposition. We need to go back and read all of that, and we get a sense of how you talk, especially in the civil case. So I can't say that we got it all. I can't say that we don't have it all. Again, I don't know what I don't know, but.
Okay, like, you made that point with 1 sentence, and now people are like, you got to cover the Murdaugh trial, and I'm like, I want to, but I also really don't want to deal with this shit. Oh my God.
I think we will be very diligent. One of the other things we talked about is how Murdaugh's access to that information in a way that makes it convenient for him and doesn't inconvenience anybody else. We'll talk about that. That's another motion we'll talk about.
I'll get to your motions in just a little bit. What I really want to know is about phone records, text messages, cell phones, video recordings, toxicology, fingerprints. You have all that discovery.
We're not sure, but we need to review it as if we were getting ready and it's brand new. We looked at it 5 years ago, 4 years ago. Doesn't mean we know we have it. We'll be diligent in doing that, but certainly I would think it'll take us some period of time to review that.
Yeah.
Meanwhile, Murdaugh doesn't mind, because the longer Dick Poot talks, the longer Murdaugh is not in jail. So Murdaugh's like, you know what? You just keep on chatting, man, because I'm sitting in a chair. Nobody's gonna stab me in here. I'm just like everything's fine. And so Murdaugh's like, you just keep talking. I'm just gonna let this all blend in.
Right. One other point, remind me, we did not have OnStar data on Mr. Murdaugh's vehicle until halfway through the trial. That is not the attorney general's fault. That is DNC's fault for not furnishing it. We had to do that on the run. We want to go back and analyze that, have an expert analyze that even more. I do want to emphasize the attorney general about it at the same time. We got no inference, anything improperly.
Okay.
So part of what we need to do, we need to hire additional experts based on some of the views we now have on some of the witnesses, both the state and the defense have. And they need to examine those reports to determine whether we have it. So it's going to take a little bit of time, Judge.
I could have gotten this done, like Poot's whole thing done, in like less time than it takes Poot to have a bowel movement. Judge, the problem is you want a timeline from us. I understand why you want it. We want to get you one. We don't know what we don't know at this point. We do have to do a lot of review. We have to look into getting experts. We have to look at this with fresh eyes. A lot of time has passed. And fundamentally, I don't have an answer for you, but I do promise that we will be diligent and we'll get this done as quickly as we can. Do you have any questions, Your Honor? Cool. Poot's still getting his pants down at that point. So
I can't tell you today we have everything because we don't know.
Okay. Let me ask you, Mr. Waters, what about the OnStar data? Do you have all of that?
Yes, ma'am. So, Your Honor, we actually SLED had sent 2 search warrants to GM well in advance of the trial, and we're told we ain't got nothing. And I think what happened was during the course of the trial, we actually had the FBI buy a Suburban and essentially reverse engineer the black box in the Suburban in order to provide us telemetry data, which of course is all provided to the defense. I think when that testimony came out during trial, somebody at GM was watching and they were like, uh-oh. And so in the middle of the trial, I get a phone call saying, about all that OnStar data, actually, we got a bunch of it. We immediately advised the judge, advised the defense, provided that to the usual form. They assisted and agreed to go forward because each hour curious about what had done. So that was nothing but the fault of the state, and we immediately engaged in what we needed to do to ensure the defense had access to all that information. As to him saying, we don't know what we don't know, well, I know my obligations are, and if I have knowledge of something that's disclosable, then it's been disclosed. And so to imply that there's something out there, we're always constantly auditing that and doing our obligations.
Longer.
Discovery obligations, very, very seriously. And knows that. As far as these musings, I have not specific to the interview. The musings of some captain about whether the scene was clean. Well, there was evidence presented at trial that there was standing water on the concrete pad of the kennels. That the hose was not put back the way that it normally was coiled by the person who was in charge of taking care of the kennels. So he may have been talking about that, but ultimately, while Colleton responded initially, the scene actually was in charge of the process by SLED, and they've had access to all that information. So to sit here and imply we don't know what we don't know, well, I recognize that, but I know that my obligation is to provide that information to the defense. And if I'm aware.
This is like watching Foghorn Leghorn argue with a mirror. These guys need a swear jar for I don't know what we don't know what we don't know. So
that has been provided, and we have done that. They had it well before the original trial, and we will continue to do that. And as he freely recognizes, the OnStar data came in late despite our best efforts, and immediately disclosed to them. They had every opportunity to process that information, and then they agreed, you know what, let's continue on. So that's not any sort of indication of a bad process right at this point.
So the bottom line is they have everything that you have.
To my knowledge, yes, ma'am, and we were very careful about going through all that discovery.
And you don't know of anything else that needs to be analyzed at this time?
Well, again, we have that DNA.
The DNA, and I'm going to get to DNA in just a moment.
Of course, it was analyzed ahead of time. Now, whether
right.
Some additional capability, as I expressed in our motion, and Mr. Griffin has responded, I'm happy to facilitate discussions. And if there's some capability out there that's beyond the capability of SLED, and it has a reasonable chance of providing some sort of analysis, then we're happy to do that. Now, of course, if we put in our motion, ultimately, there's absolutely no evidence that Maggie Murdaugh was in a struggle with anyone, that she had any sort of defensive wounds, that she was scratched any sort of attacker. And we also know that it's very common with how sensitive touch DNA is. We're constantly shedding DNA and picking up DNA from others by shaking hands and doorknobs and all the rest of it. So, this is a bit of a red herring, but that doesn't mean that we are not willing to discuss with the defense anything that they want to do if reasonable. We'll be the first to react, and if that needs to come back to this court, we'll do that as well.
Okay, thank you. Sure.
We know from testimony in the first round that the chief site officer involved admitted he misrepresented things to the grand jury. Since the trial, the case was dismissed, in which he testified because the judge found he was hiding evidence and misrepresenting that. That's the chief officer. No other question, but it raises questions with us, not whether it's been withheld by the state, by the prosecution, but did he give them everything he had? Did he do what he did in the Substance case after the trial, where he had evidence? And I think we've got to go through it and look and say, are there gaps here? Are we missing something? And for us, and look, we want to try this case as quickly as possible. But what we don't want to do is not be prepared based on what we now know happened at the first trial. And we'll have a motion probably next week that will expand on that a little bit. We didn't feel we wanted such a motion.
Well, and I don't. I really wanted to go over and see where we were with discovery. I want to set a timeline. I want to set out some pre-trial conferences, and I want to set a trial date. That's why we're here today. And I want to go over some of these motions. I think some of them are not substantive, that I could go ahead and rule on those today and be done. And I will set up a pre-trial. I'll give y'all some dates and hope you brought your calendars. And we'll set a pre-trial. I don't know that one pre-trial is going to do it for this case. We'll probably have several. And that's fine. The court's amenable to anything that y'all need. And happy to hear what you have. If you find something, Mr. Harpootlian, that you need to bring to the court's attention and you want to file a motion, I am more than happy to hear it. Okay? All right, so let me move on to my next notes. And we've kind of touched on it a little bit. Experts. Do you know how long? And the reason I'm just...
Can I just say I like how this judge is able to take the 45 minutes of lawyer gibberish and is like, okay, so let's just boil this down. Let's just do this in like a couple of sentences.
Asking is because I do want to set a trial date. Believe it or not, overnight when I was assigned this case became the oldest case on my docket. And anybody who knows me knows that I will move an old case. And I intend to do that with this one. So I'm asking Mr. Waters, expert witnesses, do you know how long you need to get expert witnesses and talk to people and get everything that you need for the prosecution of this case?
Yes, ma'am. So the vast majority of our experts would be SLED. So I think that we are ready within reason, of course, to move this as expeditiously as possible. We do have another expert that testified from the FBI and things like that, but much of that is the same. And so as far as the state's position as to scheduling, and I know we've already sort of stated this publicly, that we were trying to do this before the end of the year, like before the end of the year, we're ready to go. So I'm not aware on the state side of any expert issues that provide for additional work.
All right, Mr. Harpootlian, how about for the defense?
We have 8 expert witnesses. All of them are new. All of them are just beginning to get the information they need. The DNA, when we are told, may take up to 6 months. It is, unlike what's been represented by the state, critical. And Mr. Griffin will address the specifics of that in just a moment. But
another expert that testified from the FBI and things like
Okay, I don't know what happened there.
much of that is the same. And so as far as the state's position as to scheduling, and I know we've already sort of stated this publicly, that we were trying to do this before the end of the year, like before the end of the year, we're ready to go. So I'm not aware on the state side of any expert issues that provide for additional work.
All right, Mr. Harpootlian, how about for the defense?
Your Honor, we have 8.
So the prosecution always has a tremendous advantage on experts. And the reason why is because the prosecution has like the government institution of experts. And so it's like, okay, they have basically armies of experts ready to go. The defense, on the other hand, has to find people and has to like do the tracking down. So it's always more of a pain in the ass for the defense than it is for the prosecution. Plus, the prosecution's experts are all paid on salary, right? Or at least the ones who are already police are paid on salary. So they don't cost anything extra. And if they did cost anything extra, they have the unlimited budget of the taxpayer. Whereas the defense has to find the money somehow. So it's never really a fair system. That's why the prosecution tends to have more experts than the defense.
Expert witnesses. All of them are new. All of them are just beginning to get the information they need. The DNA, when we are told, may take up to 6 months. It is, unlike what's been represented by the state, critical. And Mr. Griffin will address the specifics of that in just a moment. But to try this case this year, I'm going to the death penalty 4 months ago or 3 months ago. Try it before the end of the year. It cannot be done for us to be adequately prepared. And we talked about the laptop. Without the laptop, we can't try it next year. If we have to go down there and take in the bank box at a time to read documents, almost 20,000 pages of documents. So we came up with a way to expedite.
Well, surely, Mr. Harpootlian, he reviewed those before his first trial, did he not?
5 years ago. I mean, it's just a judge. I can't remember a case I tried 3 months ago when the material was on. It's ridiculous to require him, with all due respect, to require him.
It's ridiculous. Sorry, Judge. I don't mean to shit in your cornflakes. I mean, I get his point. 5 years. If you asked me to remember like the disclosure on some random file from 5 years ago, can't do it. But I mean, a case like this is a big case. So I think the judge might be like, you're saying you forgot this case? I don't think it's unreasonable for him to need to re-review it, though.
To have a memory of each document that he looked at almost 5 years ago. And by the way, our solution to that, I'm afraid Mr. Waters' motion is ironclad. There's no chance of it being distributed. We'll give them a laptop that's encrypted. Since there's no attorney-client on it, corrections can look at it. SLED can look at it. Anybody can look at it. And let him look at it without us having to take hard copies of stuff down there and review it with him. Can't leave it with him under the court order because the procedures can't take him to discovery and leave it with the court order prohibiting that. And I'm sure the warden does not want boxes and boxes of stuff sitting in his. But if we have that, and he could be reviewing these documents and experts as we're reviewing them. I mean, let's not forget, he's a lawyer. Now, he's a disbarred lawyer, but he has probably more trial experience than many of the folks on either side of this court. So he understands what he's looking at much better than any client I've ever had. So I think it's important if you're going to try to expedite this for him to have, and you can talk about the laptop separately, but that's going to be a condition. It's going to take us at least 6 months to get these folks contained, have them look at the adequate material, look at the state's testimony that will come around. And of course, if they have a change in who they're using, taking a different approach, we need to know that as soon as possible. I would point out that they were giving us discovery in the last case after the first week of trial, in the second week of trial. So we can't have that happen again. They say they got it all. You can assume we have it all unless they want to supplement it. They supplement it sooner rather than later. That allows us to expedite. I mean, I think what we probably ought to try to do is figure out a trial date and then back up from that. What we're comfortable with is late spring, early summer next year.
Okay.
We can live with that. Given, I mean, if we have to go down there, one of us has to go down there 5 days a week. Incarcerated on one mouse, it's 2.5 hours. It's a half an hour to get in. So before you even see it, it's 3 hours. And then you only have 3 hours with them, and then it's a 3 hour trip back. That's why the laptop is so important.
Okay. Mr. Griffin, anything you'd like to add as to experts?
I have been in contact with the DNA lab in Houston. I can tell more about that. But when I mentioned that, they were asked, how soon do you need it? And I said, well, hopefully we're looking at a spring, early summer trial date. And the answer was, well, we need to put a rush on it. And I can talk more about the lab if Your Honor wants to hear it. I mean, they are.
I'll get to the DNA in just a minute. And then we'll go forward on that. All right, let me talk about this computer at the Department of Corrections. I did
I'm
receive
sorry, it's the best
your
I can do.
response, Mr. Waters, yesterday at 5. Did you get the opportunity to look at that, Mr. Harpelian?
Yes.
I mean, basically, I just made myself some notes. You were concerned about the state grand jury material and talked about a protective order and some other issues. I agree about there are some sensitive issues. The state grand jury material is protected and should be protected. And then you mentioned an order that Judge Newman had. I kind of think, Mr. Waters, that when this case was reversed, that order goes out the window and we might need a new order for this case.
I would put a new order in out of an abundance of caution, just to be like, look, we had an order. I don't know if it's still in effect. We're going to redo it. I saw somebody asking, do I think he'll testify again? I kind of suspect. I think he did. I think he thought that he did a good job. And if you watch the first trial, how do I put this? His testimony was like the equivalent of trying to piss out a fish hook. It was really bad. Yeah.
It's my understanding that the order stated that the grand jury material is secret. And I mean, that's pretty straightforward. And I know that you would like to prohibit the digital dissemination of the state grand jury material, that there's no photocopying, scanning. I breezed through this. You don't want any digital copies. And all of this, while it doesn't prohibit the defendant from reviewing the case materials, you want the attorneys to make sure that they keep in their possession the state grand jury material. Is there any objection to that, Mr. Harpelian?
Well, Your Honor, the issue of that is, what is the state grand jury material? I think, if we can designate what that is. It's beyond grand jury testimony, which is, there's very little of that in the discovery. I think they've gotten things through grand jury subpoenas that have been produced, underlying records and whatnot. And so, is that really sensitive grand jury material? And some of us introducing evidence at the trial, I'm sure of that. But so no question about grand jury testimony. We have no issues with that. But it's just hard to say what exactly are grand jury materials when a lot of subpoenaed documents and information have been produced.
And Your Honor, the issue is dissemination. I mean, he has the right to read.
Oh, absolutely. I said that. It does not.
I mean, what I'd be pitching if I was Poot's team here is to say, Your Honor, the issue is dissemination. What I suggest is that we give him a laptop and that we modify the laptop. We disable the USB drives. We disable the ability to connect to the internet. He's got a laptop that is air gapped, and all he can do is look at the grand jury materials on it. Prosecution, if he needs another laptop, we could have two laptops and just make it so that the two things cannot, but that should solve the problem. He can't upload it. He can't copy it. It's not like he's got a hidden USB drive. Even if you're worried he's got a USB drive in his prison wallet, he's not going to be able to fix the laptop to make it connect. So what do you want?
Prohibit him from reading it.
Dissemination. I mean, we're just basically talking about a big Kindle. You can read on it. You can't send email. It's not connected digitally or cell or Wi-Fi to anybody. It can be. I want to say this: the Department of Corrections is extraordinarily professional in dealing with us. giving us access to that. But no complaints with them whatsoever. But what we'd like that laptop with the warden and corrections have total access to it. It can be inspected by SLED to make sure it can't transmit an image, a message, and be used in any way. There is no Wi-Fi at this particular institution. So it has to be by self-service. And these are not difficult technical issues. And if they're concerned about grand jury testimony, we have to take that out. That's very difficult. What we want him to look at. And we can certainly do that separately with hard copy. We have to go out there and do that.
Well, let me tell you. Well, Mr. Waters, let me hear from you first.
Yes, ma'am. So we really, as far as the check board, we really have two things. There was the state grand jury investigation, and ultimately there was the standard protective order for that. He's pled guilty to all of those offenses. There's nothing more about that. But necessarily, as that state grand jury investigation was going, things came up that were ultimately relevant to murder. So it was much bigger than they say. You know, I don't have a number in front of me, Your Honor, but it was at least 20 witnesses, multiple subpoenas, and so all of this was in that evidence, as well as Judge Newman issued a second, my recollection, protective order as it related to just sort of the murder evidence as well. So they're two separate things, but they all blend together. So all of this evidence is sensitive. On top of that, the murder evidence is in fact very, very sensitive. Frankly, we've been trying our best to protect it from improper dissemination because it's worth a lot of money. Now, one thing SCDC is adamantly opposed to is having an inmate have a laptop. They are absolutely 100% opposed to that. And I have to remind you that this is an individual who already had his tablet privileges taken away from misuse of that. This is an individual who...
Wait, I want to know how he misused his tablet. Like, did he stab somebody with the tablet? Was he watching, spicy videos on the tablet? Like, what was with the tablet misuse?
Was caught receiving contraband that was passed from a family member who was to him. And so this is not a guy who is, and this is also a guy who's been convicted of over a decade of fraud. Now, they say that these things can be locked down and I understand these issues very well. The state grand jury made a point to partner with SCDC to fight the problem.
It can't have been Baby Shark that he was playing, because if he played Baby Shark, that's a death penalty offense. So I also just got to say, how is it that Murdaugh looks this fucking creepy? Like, this dude looks super creepy. And Murdaugh had more money than God. Like, this guy had so much money. And I'm just going, how do you make that much money when you look like Frankenstein's ugly kid brother? This is... I don't get it. Like, there is a strong correlation in law between, like, attractiveness and income. It is not... It is a huge, big correlation. And yeah, I mean, maybe he's just really good, but nothing he's done in this suggests he's actually really good at it. So, yeah.
Fraud and corruption emanating from there, and it's done with the use of devices. This is a very severe security issue. No matter what protections are put in place, there's always ways around this, and SCDC has experience with that. So the fact remains is he's an inmate, and SCDC adamantly opposed to there being some laptop that he has access to. And for this idea that SLED is going to be able to review, attorney communications and work product on that, I don't understand how that's going to happen. Now, SCDC is happy to accommodate this, and to any meetings they have. And no one says that the defense can't bring down digital evidence to review with them.
Look, I know what I've got.
And then with them when they leave. That is absolutely the way it should be. That ultimately this information, whether state grand jury or not, is too sensitive to have an inmate, despite what protections are put in place, have a laptop. Because frankly, the reality is inmates are constantly and successfully violating whatever protections are put in place. Despite everyone's best efforts, you're doing a great job. It's just a measure.
Okay. Sure.
I had a series of emails, and I don't see the Department of Corrections here today. I had an email chain with Ward at a particular institution, and he doesn't raise those objections. He just, and we bring another laptop and can't have cellular or Wi-Fi capabilities. So, and that's what this says. So, And with all due respect to the Department of Corrections, if you don't get the ability, I mean, if Mr. Griffin and I, or Mr. Barlow, or Ms. Fox have to go down there, 3 hours down, sit with him for 3 hours, 3 hours back, we're talking about at least the end of next year, not the beginning of the following year, to get this report. We can't be working on experts. We can't be interviewing witnesses while we're tied to sitting there and babysitting him while he's reading a laptop.
I'm just gonna say I really actually agree with Dick Poot here. He should be given a laptop. He should be allowed, and it's kind of ridiculous if he can't. I have had clients who I had to babysit. I had a client who was allowed internet access only in the presence of counsel. Now, it was alleged that he'd done really bad shit with the internet, and so, like, he was allowed to do anything reasonable on the internet so long as, like, I was supervising. And man, does that suck ass when you're sitting there and, like, some guy is checking his, his email and, is, like, looking up local restaurants and, and you're sitting there going, okay, but, like, are we serious? So, the client hates it. You hate it. It's just, it really sucks. So somebody says, does DoorDash deliver food in jail? No. No. That had to get old in a big hurry. So the most awkward conversation that we had, me and this particular client I'm thinking of, this client's charges were not porn related, but the guy was in my office looking at, like, on his computer, and he's like, is it okay if I browse porn? And I was like, not in my fucking office. And he's like, but I can't do it anywhere else. I'm like, I don't care. We are not doing that shit. Like, no. No. So, yeah, I was not ready to have that kind of relationship with the client. And I did eventually tell him that it would be okay if he used that to subscribe to a porn magazine to be, like, mailed to his house. And so, yeah.
Doesn't have any capability to communicate or talk. And we'll be happy to have SWED inspected. We'll be happy to have the Department of Corrections inspected. But, the idea, we bring laptops in. We were given, as you can see, permission to bring laptops in. Laptops are brought in all the time. The question is, can he keep, not he, but can the warden keep it, or some office at the institution keep it and give it to him when he needs it? And Your Honor, I gotta say, the idea of bringing him in here chained up, the idea of not letting him have access to a laptop, the idea of opposing everything we're trying to do to expedite this process, I understand it's Mr. Warner's job to legally prejudice the defendant, but this is beyond the pale. This is beyond the pale. I'd ask you to remind Mr. Warner that he has an ethical duty to see that justice is done, not get it.
Ooh, you gotta be really fucking careful. This is one of those things where you have to be, you gotta be real cautious, because if you're gonna say the other side has an ethical duty and you're gonna start implying the other side is violating their ethical duty, I'm just gonna say you need to have the judge already on side. Because if the judge thinks you're offside with that, the judge is going to metaphorically stab you in the possibly literal kidneys. So, like, think real hard. I don't pull that trigger unless I've got the cards. That I kind of mangled my metaphor, but
Thank you. Mr. Harper, I don't.
And that,
Okay, we're not going to go there.
and I have no intent to prejudice anyone. Prejudice suggests a decision on an improper basis.
And the court doesn't take it that way, Mr. Waters.
Thank you, Your Honor.
All right, let me tell both of you. I took the liberty of calling the warden and talking to him about the laptop situation. And because I too used to practice law, I remember terabytes of discovery that I had to carry to my clients to go see. And I know that it can be cumbersome, and I would imagine the discovery in this case is a lot. How many pages do we have, Mr. Waters?
It's very extensive. It's half a terabyte.
Half of a terabyte, okay. I talked to the warden. He will not allow a laptop. And for safety reasons. He said he would, quote, make available a conference room. Counsel may bring their computer. They could have a law clerk come, or the attorneys could come themselves. They could look at it. He could review his discovery. They could bring their own laptop. However, somebody must be with him. His concern was having a laptop in his cell. No other inmate has a laptop in their cell.
so don't put it in the cell. Bring him into a room and put the laptop in the room and have him look at the laptop only in that room, but he doesn't get to take it back to his cell because, I mean, I just feel like I get why they don't want to have it in his cell, right? Because some other inmate will take it, break it, and then stab somebody with like half a circuit board. But and the other thing is the warden won't allow it. You know what the warden will allow? Anything that is fucking court ordered. So yeah. Oh, this is cool. I named one of my baby bluebirds Runkle. That is awesome. I now am curious about Runkle the bird. So
They do have access to an iPad that has Westlaw on it. Now, I just have to be honest with you. I didn't even think about asking him if you could download any discovery on that iPad. I don't know if that's available, but I certainly will call and check and see if that's acceptable to him. If that's the case, I'm going to have Mr. Waters draw me up a proposed order on the state grand jury material. I haven't looked at Judge Newman's yet, but I will. Please run that proposed order by Mr. Harpoolian and Mr. Griffin. I will check on the downloading on an iPad, but I'm not going to allow him to have a laptop computer in his cell. It's for safety reasons. That's out of my control.
yeah, don't have it in his cell. Have it that he, flags them down, gets brought into that same conference room. The laptop is parked there. There's a guard outside. He's locked in. He sits there. He's on the laptop until he is done with the laptop. And then the guard takes the laptop and puts him back in his cell. Like, no problems.
I think it's not only for the safety of the others at the institution, but probably, Mr. Murdaugh, for your own safety. Okay?
We're not proposing he have it in his cell. We're proposing that the warden have it and give it to him to go to a conference room as he would with us to look at it there. Does that make a difference?
Well, I'll ask him.
Judge, you are the judge. There's a certain point where you need to stop asking and start telling. Because, so in a local Edmonton case, I know that one of the judges, there was a guy who was self-represented. He wasn't my client. He was self-represented. And he was like, I need access to my disclosure. And they're like, well, we're going to mail it to him. And he's like, yeah, they already mailed it to me, but they mailed me like CDs and I need time to actually, I need to be able to have a computer and I need to I need a moment for all of this, and I need time with a computer. And the remand center said, we're not able to do that. We're not willing to do that. It's not going to happen. And the judge said, okay, I am going to stay this file in 30 days unless he is able to unless he's able to view his disclosure. And sure enough, they found a way to show him his disclosure when the judge is like, either you figure this shit out or I'm throwing the case out. Just lock the door on the conference room.
When I read your email here, this seems like he could go to his cell. He could keep it in his cell. I know good and well that the warden is not going to allow that. I talked to him personally. Okay. We'll follow up on that in our next pretrial. Or if I can, I'll probably let you know before pretrial. But if he says no and it's for security reasons, then the answer is no. I'm not going to allow it. Do you understand, Mr. Harpelian? Mr. Waters? He'd let a paralegal go. All he wants is the name of the person, and you're more than happy. And he said he's not going to limit you to 3 hours. They can stay 8 hours if they want. He will make a conference room available so he could see the material. It does not have to be a lawyer. Okay, that.
Your Honor, I spoke with the director of legal counsel this morning, and they expressed the same thing. We're here to facilitate the defense doing that.
Right. I want him to have all his discovery. He's entitled to all of it. It's safety concerns.
I've done this where you're sitting with an inmate reviewing documents. Sometimes you're sitting there and they just want to read them, and you're like sitting there and they're reading it. I've done this in maximum security prisons with guys who were very murdery. And you're sitting there and this guy is like reading over his, and I've helped a client who couldn't read very well by he's like, I don't know this word. And you walk over and you're like, that word is this, and here's what it means. And I realized at a certain point, it's like, I am teaching this guy how to read. Yep. So Jake has a good question. Is that not really scary? Sometimes. It depends on the client. Because I've had clients who are like, I put it this way. I had a client who was, convicted, like a convicted murderer. And quite literally, I would have let that guy watch my dogs. I would have, that guy was a stand-up guy. I had no actual concerns about that particular convicted murderer. But I had a client who was a convicted murderer who was in the max. And I went to visit the guy. And so I go, and they gave me this panic button. I need to embiggen so I can show you this thing, or show you the panic button is like this. It's this giant thing. And, it's got this big red button on it. So I walk in and I've got this giant panic button. And, I'm setting it down, and they bring the guy in. And the guy looks at me and he goes, if I wanted to, I could kill you before anybody gets here, whether or not use that panic button. And I'm like, I know. And he's like, okay. And then he's like, I'm thinking about it. And I'm like, okay, well, can we get on with this? Because either you're going to kill me or we're going to handle your stuff. So which is it going to be? And he's like, all right, we can, we can do that. So I'm just like, yeah, this was a guy who was seriously a bad dude. And I was not super comfortable with that guy because, when you've got a guy who is in prison for murder and he's openly contemplating murdering you, it's not the most fun place to be. And so it's like, all right, guy's like, yep, I could murder you. And it's like, yes, you could. Like that is a thing. And what is it? I would withdraw. We got along a lot better. And like a lot better afterwards. So after he sort of did his creepy ass shit, he eventually decided he liked me. And one of the things he said is like, if you ever end up in here, you're okay. I've got your back. And I'm like, if I end up in the maximum security prison, you've got my back. My game plan is not to end up in the maximum security prison. And but thanks. This is also the guy who, when I asked him at one point, I was like, don't you want to get out? He's like, nah. I was like, what do you mean you don't want to get out? And he's like, I like it in here. Like, you're in the maximum security prison. You like it in there? He's like, yeah. On the outside, it's a really big deal if I want to kill anybody. Like, it's a big thing. In here, I can kill anybody I want. I don't want to go anywhere. And I was like, oh shit. Like, I was like, right. Dude who is happy in prison because he can murder whenever he feels like it it's kind of a vibe. So, yeah, just straight up. I can't really give many details of like his offenses, but he was a violent dude. So, all right, back to Dick Poot.
If you can have a law clerk or a paralegal go down, then you're satisfied. Mr. Harpootlian, that'll help you out.
Automatically, if not limited to 3 hours, it makes that 2.5 hour trip down and 2.5 hours back worthwhile.
Okay. Well, then I will verify that and send y'all an email tomorrow on that. That's okay. All right, perfect.
Thank you, Your Honor.
All right. Now, let me go through.
No, he wasn't.
I had a motion filed for the defense, and I just want to put this on the record. The defense wanted the defendant to be unshackled in the courtroom. I received a response from the state. They objected. Then I had a response from Mr. Harpootlian where he withdrew that motion. That still stands, Mr. Harpootlian?
Yes, Your Honor, although we may renew the motion, the reason for this is potential jurors are watching this right now. It's going to be, wherever this goes, it's going to be difficult to get a jury. And the extent that parading him around in a jumpsuit shackled like an animal impacts their view, it's going to make.
I mean, I don't think you're going to find a juror who is. I don't think you're going to find a juror who's not aware that Dick Poot was previously convicted, unless you like literally find this guy in a hole. So yeah, okay, but did he kill anyone in prison? Not while I was his lawyer, but not for lack of trying. So,
more difficult for us to get a jury. Now, again, Mr. Clark's argument is specious. He's not dangerous. He's only been convicted of stealing money. Now, Judge Newman.
The only thing he's been convicted of is stealing money. Yes, but he's on trial for murder. Like, oh, Murdaugh, right. He's on trial for murder. So
let him come to the courtroom in street clothes and unshackled. I know Mr. Waters feels compelled to get every advantage he can, but this is one that
stop. Dude, stop it. Don't throw shit at the other side unless you've earned it, and I don't think you've earned it.
this is our ability to get a jury. So I ask that he be allowed to come in the courtroom unshackled in, I will call them street clothes. Now,
So are you renewing your motion now? Just want to make sure.
what I wanted you to see today is this. I mean, chained around the waist, chained to the hands, chained on the feet. I mean, this guy is not a serial killer. He's not, Ted Bundy.
You can sit down, Mr. Mayor.
He's accused of killing his wife and son, but he was accused of killing his wife and son, and Judge Newman allowed him to come unshackled in his street clothes.
He's like, Your Honor, he's no danger to anybody he's not related to.
Every hearing we had.
All right, Mr. Waters, I did read your response, but I'll be happy to hear anything and I'll take it under advisement.
Well, again, they withdrawn the motion and now they.
Now they,
This goes back to, it's not the state's fault he's an inmate serving a 27-year sentence, okay? This is, again, SCDC's policy for a non-jury court to be dressed out in restraints. He not only faces 27 years, but an additional 40 years in federal court, and he's also indicted for a double murder. So this is a basic security consideration. Again, the intent is not to prejudice anyone. The intent is the security of every time someone is transported out of court. It is a security risk. And the first two goals in any escape attempt is to become unrestrained and in civilian clothes. So I'm here to represent what is basic policy and procedure for inmates serving long, felonious sentences with SCDC.
Do you really think Murdaugh is going to try to escape? Like, where's he going to go? Do you think that Murdaugh is going to run somewhere to, like, a place where nobody's going to recognize him? The dude is, like, highly recognizable, and he looks like a toilet brush. He stands out in a crowd. So I don't see that he's going to make a run for it.
Completely understand that we have a jury, the calculations are different, and that is going to be a different thing to do. But the remedy for all of that ultimately is our process. It's going to be jury selection, and it's going to be instruction from the court, which the jurors need to follow. I know our citizens can.
okay, thank you. All right, I'll take it under advisement. I'll issue an order on that. Let me move on to the DNA. Again, I just received the state's response yesterday at 5 p.m. I read it, and I'm going to save it for the next pre-trial because this is what I want to know. I'd like to know how long, Mr. Griffin, it's going to take to analyze exactly what it is you're asking for. And I believe it's genetic.
Yes, Your Honor. And the state's response says, give us somebody to talk to at the lab.
Okay.
So
And
that was conveyed to them this morning. The CEO of Othram's name, email, and telephone number. They have received the VP of Law Enforcement Division at Othram, his cell phone number, and the client intake person that we use now, that I've been interfacing with. And they will be better able to answer specifically how long it will take. We've agreed to pay for it. And just background information.
I'm going to let you pay for it.
Yeah. And these murders happened in 2021. We're in 2026. 2021, there's no such thing as artificial intelligence. In 2021, this genetic genealogy was just on the ground floor. In 2026, we are light years ahead. And so what we're asking for didn't really exist in 2021. It does exist today, and Othram is the leading lab that performs this analysis. They did last year on 2024, the statistics are that they cleared 200 cold cases on behalf of law enforcement around the United States and the country.
Okay, you want them as an expert. Get to the fucking point. Oh my God.
They work with law enforcement every day. The most high-profile case they did was at the University of Idaho, the Moscow, Idaho murders that took place about the first week of our trial. College kids were massacred in a house at the University of Idaho.
Nobody cares. oh my God. Deep breath. I don't know why these people are the way they are. It might be genetic. It might be a birth defect. It might be something that I would feel bad about mocking them for.
They had a DNA sample. They ran through CODIS. Came up nothing. There was nothing. The state of Idaho police had a contract with Othram. They sent the test Othram. Othram does this genetic genealogy DNA analysis, and it comes back to a family member who'd done a DNA test, ancestry test, of the person who committed these murders, Brian Koberger. That's how they solved the Moscow murder cases, was through Othram lab. The difference between, and they say they don't have enough samples to get through CODIS, and I've talked to the lab about that, and that's not an issue. CODIS uses an analysis called STR. This analysis is SNP, and they call it SNPs. CODIS has 20 data points. SNPs has half.
Dude, just say there's a lab. It didn't have the stuff that we want, or now it does. We really want to get this lab to test it because we totally think that they are going to acquit because they're going to, discover the real killer. Like, cool, do it. Like, just move on.
A million data points that they analyze. Now, it takes a while to do that. And so, we're going to have to see what the lab says. They've asked me to get information from SLED as to, they like to see the electropherogram or mixture proportions so they can have a better handle on it. And I'd ask Mr. Waters to give us a name so that these experts can interface. But what they're doing in Houston, Texas, they don't do in South Carolina at the SLED lab. And there are handfuls of labs around the country, and they are, they're certified. They work with law enforcement. I don't know that they work specifically with SLED. They're familiar with SLED when I spoke with them, but they have a whole division.
So you need an expert's name or whoever has this sample to see if there's a viable sample that you can send.
Correct. And they can work with the extract that SLED used when they did their SDR analysis. They can work with that out there. They told me. But
Mr. Waters, can you give him a name so he can move forward?
That's what I put in my motion, Your Honor, is please give us a name, and I'm happy to have SLED reach out and talk to them about what their supposed capabilities and proposals are and any procedures. And I'm then, once made privy to that information, I'm happy to discuss those with the defense. If for whatever reason we can't agree, we'll come back to the precisely what I put in my motion is let's talk to let the experts talk so that my experts can hear what it is that they propose to do. And I'm happy to do so.
And I gave him 3 names and contact information this morning, and I've asked a name that I can send back to my folks. I do want to address this red herring argument. The DNA that we're talking about, Your Honor, came from Maggie.
Man, I like the lawyers in this case about as much as I like sandpaper underwear. This is they're making what should be a really short process into this absolute misery.
Murdaugh's left fingernails. That was tested by SLED with this STR analysis. The DNA sample number 70 that we're asking to be tested, it positively was not Alec Murdaugh's. Any of the other folks who they took buccal swabs from went through a long list, not them, except for one potential. And that potential, the ultimate result was it's 11 times more an unknown male, so they know it's a male, than it was this person. That's how they do things in their DNA analysis. And Mr. Waters said, well, there's no evidence of struggle, but there was a shell casing under Maggie Murdaugh's body from the gun that killed her. I mean, that shell casing and that gun had to be in very close proximity. Maggie Murdaugh's cell phone was missing from the crime scene. Was DNA transferred at that point in time? And so we don't think it's a red herring. We think it's very important. Now, it may turn out to be, innocuous. We don't know, but it's worth looking into.
Okay, I haven't said no. This is what I do want you to do, though, Mr. Griffin. I want to know how long it's going to take to analyze what it is that you're asking for. And even if I expedite it, I'd like to know how long it's going to take. And I'd also like to know if there's even a viable sample that they can get. And we will discuss this at our next pretrial. Anything Mr. Waters, you're going to give them the name of the person that's led that he can get in contact with. Let's see if there's a viable sample.
And the lab has told me if there's not a viable sample, we'll tell you that. But
Right.
they work with a lot less than.
Okay. Well, let's start with that. Let's make sure we get a viable sample, and then we'll go forward. And we're going to go forward at the next pretrial. I promise you, the pretrial is not going to be that far away. All right. Let me move on to the motion for change of venue. The defense filed a change of venue motion. The state has not had the opportunity to answer yet. So I'm going to give them time. In the meantime, before our next pretrial, if at all possible, if y'all agree on a change of venue, please give me some suggestions if y'all can agree on it. If you can't, make your own suggestions.
I mean, where are they going to take this that people haven't heard of it? Like the moon? They're going to have a change of venue to the International Space Station. And the jurors are going to be like the astronauts and the electronic toilet.
And then I will decide for you if we go that route.
Even in spite of the acrimony here today, as they able to talk to each other, and we have already talked about this. I think we'll have continuing discussions depending on each sector.
An answer for me?
Try, if I don't have to drive me down.
Yes, Your Honor. Of course, without taking a specific position right now, I
Right.
this morning that, we can take some things around. And like you just said, if we agree, great. If we don't, then we'll work it out.
That's right. Don't have a problem with that. Okay, perfect. All right, now let me address, I see Mr. McCullough sitting out there, and then I also have another, they're both the same protective order, but they're wanting two different things.
Who's this dude with the white hair?
It's not the same.
That's right, they're two different things. Right.
How
As
dare
far
he
as,
steal
but I
my
think
drip.
before we go there, Mr. Harpootlian, I believe, Mr. Waters, am I correct in stating that you're working on a response to both of these? There might be some redactions that you wanted, and you're going to submit that to the court? Okay, and I'll be able to address that at the next pretrial conference.
Yeah, we are generally in favor of those being unsealed, but they will have to be done judiciously and with appropriate redactions to preserve their identities and actions.
Right, because I did receive something from SLED, an email from SLED.
General Counsel Adam Whitsley is present here today, and Sledge.
Where is he? Okay, I did receive your email, and just get me an answer on that, and we'll decide at the next pretrial then. Okay, those were all my bullet points. So let me ask the lawyers, did I miss something? Is there something you would like to add?
One thing Your Honor had mentioned is the location of pretrial hearings. And from the state's perspective, we're happy to come wherever Your Honor happens to be.
Okay,
He's like, from our perspective, our travel is covered by the taxpayer. And also we get, we get overtime pay. So we got no problems.
More than happy to come wherever you are, although this production of these hearings might not dictate, but certainly suggest you come to a venue like Washington County, where there's plenty of room and an extraordinary
I think they've done a really good job with security and with the press and being organized. And this is my home county. Let me just ask and throw this out there, Mr. Waters, is there any objection if we hold pretrial here? The reason being, we have a big courtroom. I already have security set in place. I think the clerks and both clerks and security have done a really good job. This is not the only courtroom in this courthouse, so I won't disrupt holding court in Lexington, which I would not want to do to any county. Sometimes I go to really small counties and I don't think it would be good to hold a pretrial there. Does it suit?
I mean, from the state's perspective, you know, again, being a longtime AG, I've been in pretty much all of them. And as an AG, Lexington is like a second home, obviously.
Convenient.
Solicitors, office, law enforcement, court, of course, is very accommodating here. So this is certainly, I think, would be of most convenience for us as we get ready for work.
It's not far for anybody to travel, Mr. Harpootlian? Okay, and I will try to make sure that when we arrange these pre-trials that we will try to be here in Lexington. Anything else, Mr. Waters?
I believe that's
The defense?
That's all we have, but if we could talk about that schedule for the next pre-trial.
Oh, I'm getting ready for it right now. Let me tell you what I have. I've gone through my calendar. And so it's hard to get lawyers together, especially when I have this many lawyers. So let me throw some dates out to you. August the 13th and the 14th. July 29th, the 30th, or the 31st.
Right, so in chronological order, the first would be
July 29th,
I'm scheduled to be out of state with that from the 29th to the 31st.
okay, then let me move on to August 13th and 14th.
John, we have a mediation on the 13th. The 14th is available.
Yes, sir. 14th works for the state, John.
August the 14th it is. That will be,
I'm actually kind of shocked. They managed to get a date on the end of June. They managed to get a date for August 14th. That is some record scheduling. So yeah, Swamp Bear, maybe we'll talk.
our next pretrial. Now, with that said, I'd like to have all motions by August the 7th, if I could. I like to read my motions. I like to be prepared. So if I could have your motions, I understand that some of them are late. You might think of something at the last minute. That's fine. But please don't file something at 10 o'clock at night and expect me to rule on it in the morning. Okay?
I apologize for those coming in late.
No, you're fine.
The judge is like, don't be an asshole. That's what that is.
I came into the office just to make sure we had something out.
Mr. Waters, you're fine. I was not planning on ruling on those motions. Now, had I been, I might say something different. But please don't do that to me, okay?
That vibe is like when when I was cross-examining a witness at one point, and my cell phone went off, and I was like, I apologize, Your Honor, for my phone. I really am sorry. And she said, Mr. Runkle, this is your cross-examination, but if your phone had gone off during your friend's cross-examination, I might have a different opinion. And I was like, understood, Your Honor. That's kind of that vibe, is like, if I was expected to rule on this the next day, I would be a little more pissed. So
Now, let's talk about a trial date. The only other information I would like to know is how long this DNA is going to take. I would like to know that, but I'm going to tell y'all, I'm thinking April the 5th. And this being, I'm trying to get through Easter, and I know how hard it is to pick a jury when you've got spring break. That's usually right before Easter. It is the March. Is it the 28th? I think it's just the week. It's March 28th. So I'm thinking April 5th. You know, I know that we'll have a new attorney general coming in. Y'all, Mr. Harpootlian has already told me it's going to take 6 months to get experts prepared and ready to go. That would give the new attorney general time to look at his case in case he's going to be here and join us. And let me tell you this, tell both of y'all, I think y'all know me pretty well. When I set a trial date, I don't do continuances. I don't do it. That'll be a really good reason. So, how does April the 5th sound, Mr. Waters?
Yes, ma'am. So we're ready.
Mr. Harpootlian?
We'll be ready with some contingencies if the DNA takes longer, for instance, or
I will have that information by next pretrial. If I need to extend it out a couple of weeks, I will, if that's the case. Please do not think that this case is going to be tried a year later, because it's not. We're going forward.
More than happy with that.
This judge is like, set the dates, and if you're asking to move it, you had better be dying or dead. We did actually have a judge at one point who a lawyer failed to show up for the trial, and the judge was like, is he dying? Because if he's not, he's going to wish he was. And then it turned out that the lawyer was actually in the hospital. So that was even more funny. But yeah, it was like, is he dying though? Like, yeah.
Murdaugh, more than happy with that. I just, again, everything, like, because the science and all these areas is much better than it was 5 years ago.
I understand. Technology changes overnight. Overnight. I understand. Mr. Griffin, anything you'd like to add?
Yes, Your Honor. The Supreme Court reversed this case on misconduct by clerk of court. But the Supreme Court also
Okay, we know, but like,
address financial crimes evidence. And depending on
okay, he's getting to
how
a
much
point.
of that or any of that comes in, will determine the length of the trial in many respects. Judge Newman last time would not rule pretrial on that issue. And it is going to be an issue that we're going to have to brief and argue with Your Honor as to, we don't think any of the financial crime evidence should come in at trial. And so I'm just flagging that it would be helpful to us, I believe, and to know if we're going to have to defend against that during the trial, or are they going to be able to put it up? And so I'm just asking maybe some earlier date where we can have, your Honor address those issues.
We will. I'm just going to tell you, I like to address all pretrial matters beforehand, because when I say April the 5th, we're picking a jury and going forward. All those issues should be decided by then.
Your Honor, that's my practice as well. We filed extensive pre-trial motions prior to the prior trial, putting all our cards on the table. Is exactly why we thought that was admissible.
Thank you. I appreciate it. Anything further before we adjourn? Mr. Waters and Mr. Harpootlian?
Nothing with it. Thank you.
All right, perfect. Have a good evening.
Can I say I really like this judge? Like, she's got no bullshit, and she's not mean about it. She's not like vicious. But I like the lack of bullshit. She's just like, yep, we doing things like that. That is going to be how this goes. So I like that tremendously. Yeah. I owe you guys a story, and I owe you guys some super chat reading, and then we've got a ridiculous case we're gonna laugh at. So, yeah. First, people wanted to hear the story of the car rescue, and so I will tell you the story of the car rescue because, yeah. So, somebody's asked for a puppy swoop. We can do a puppy swoop. So, puppy swoop. Here we go. So, the car got stuck in mud. And what happened is that I was going up to my land, and the road there was not great. It was absolutely slippery, slick clay. So when the rain hit the clay basically, it turned into essentially a lubricant. And so I got stuck in the mud, and I tried to get it out. All I managed to do getting it out was to get it turned. It ended up perpendicular to the road, which was not good, and even more mired. It was off the road. It was stuck. It wasn't quite sunk to the ankles, but it was really, really, oh, good. So it was really in there. So I was trying to get it out, and I was not having any luck. I went and bought a hand winch. What do you call it? A cable puller, but the cable puller is broken. It's not, or I'm using it wrong, but I think it's broken. Sheila Court Reporter, was it at least on your property? No, it was on the neighbor's property that I have to drive, over to get onto mine. So, yeah, I tried. I made repeated efforts to get it out, and then one of my viewers, Rob, he's in the chat, Rob Price, there, was like, "Look, I've got all the equipment. I've got all of the stuff. Let me help you get it out." And I was like, "Okay, awesome. We're gonna give it a try." And the problem is it wasn't as dry as I'd like it to be, but we were sitting there, and the we were there, and the weather report was basically a fuck ton of rain is coming in. So we were going, all right, let's give it a go. Let's make it. Let's try. We drove his truck in, and we managed to avoid getting stuck, although honestly, it looked a little touch and go a couple of times for whether his truck would get stuck, but at least his has a winch on it. So then, we got his truck in. He was able to put he had a pulley. We were able to put that on he was able to put that on a tree. And so we were winching this thing, and I'm sitting there watching it going, it's not moving. It's not moving. And then finally it starts going slurp and comes out. And one of the other fun things was that the hole that the tires were in were so deep that they were full of water, and there was a big ass frog in them. So as soon as the car is pulled up, I went and checked out the hole that the tire was in, and it had this big ass frog sitting in the muddy water looking at this going like, what the fuck? So we get the car out, but now it's faced the wrong way, and so I'm having to do this like 40-point turn as I'm slowly turning because I can't go off the road again. And so I was just like going, and doing this like slow turn to get, finally turned around and get back onto the road. And so now it's like, fuck, yes, I'm out. So I'm texting Mrs. Runkle, and I was like, the car is back on the road. And it was expected to get like 3-4 inches of rain. And so I was concerned that like that much rain might have the car like sink into the mud, whatever. And the car started just fine. It's running great. The car's got no problems. It's just doing fine. But so finally, he's driving out. He gets sort of stuck a little bit, although not for long. It's just has to switch into 4-wheel drive a couple of times. Meanwhile, I'm driving my 2-wheel drive Buick. And the 2-wheel drive Buick is not built for getting out of the mud like that. So I'm going, oh, shit. I do not have the ability to switch into 4-wheel drive. So instead, I'm just... we
are here.
What is it? I'm just like, I'm going to just gun it. I'm going to just... So I take it at speed to get through those mucky patches. And I get through. I managed to make it out. And I get to the road and I'm like, oh, thank God. So I have a truck that is not yet roadworthy. The truck is an old Ford F-150. And by old, I mean it is rusty. It is, and it needs a bit of work. Specifically, it needs things like, it needs the cam phaser transducers fixed. So that's something I got to do. And, yeah, once that's done, at least I'll have a 4-wheel drive. And yeah, I got to get that sort of taken care of as quickly as I can. And yeah, it should be much better. But it is kind of annoying because the mud is super bad, like super, super bad. And I have got to get that sorted. So we'll see. I mean, it's just it's an adventure, but yeah, I got to get all that sorted out. And but yeah, the car is now rescued. It's working great. And oh my God, I'm so happy with the with having the vehicle again, because Mrs. Runkle was so Mrs. Runkle has been working from the office a lot, and I've been working from home a lot. And so when I'm working from home and Mrs. Runkle is at the office and we've got one car, I'm like, I keep having thoughts like, oh yeah, I'm going to go buy some noodles for lunch because there's a noodle place near me. And the noodle place near me is, it's really good and really cheap. I can eat like I can eat a lunch for $10 and it's a really good lunch. So, you know, but I'm like, yeah, I'll go. Wait, I can't. And people are mocking me improperly. Don't forget to keep the blinker fluid full, you bastards. But so hopefully the truck will get fixed. Hopefully all of that. The other thing is that if I get into the position to make the big announcement that I want to make, then I will need to what do you call it? I will need a second car. Like there just is no way around it. So yeah, I gotta get that done. And yeah, it just an adventure. But what is it? Somebody says fix or repair daily. Yeah. Ian could get his steps in. Problem is it's not a matter of getting my steps in. It's a matter of I have only so long for lunch, right? And like, you know, when you've got an hour or whatever for lunch, I'm just looking here, pulled up Google Maps, and I'm just going to figure out how far it is or how long it would take for me to go and get noodles. So let's see, directions. On foot. So it would be a 50-minute walk, give or take. And like I can't I can't. So yeah. Really close to what I hope will be a big announcement. Really hope. And yeah. All right. Let's cover a very dumb case. 5-0. What an electric scooter. I don't own an electric scooter, but I don't know. I don't want to buy an electric scooter. All right. So let's cover a really ridiculous case. This is idiotic. And we're going to have some fun with it. Because, yeah, this one it went up online about a month ago, and it is yeah. Oh, I also owe people super chats, so let's read those. So about your trip to Seattle, any info you can give yet? Not yet. We'll see. It's me, Tony P. Beer me. Joanna Laura PhD, thank you for the live stream. Thank you. Vez from Quebec, boosting the goal. I want a beer too. I'm wondering, Quebec's probably got some good beers. Vomit Fountain says Runkle needs a beverage. Not the username, though. Ms. Vicky, Gold Cash, thank you. Joe of the Masks, I'm at work, no beer for me. Reasonable. Nancy Druby, have a beer for your good citizenship. Thank you. Sin the Knitter, thank you so much. I thought that was like Sin the Kitty at first, and I was like, nope. Kylie, Mother of Ducks, no one let Poot Poot anywhere near a firearm. Yeah, I was not pleased with that. The World Wonders, you're not wrong. Corona gives Mexico a bad name. Yes. Modelo is so much better. And it's been a while since I did a Taco Tuesday. I kind of want to do that. Tomorrow is date night, me and Mrs. Runkle. I'll see if she's up for tacos, but she might not be. Chloe diagnosed snarky. You'd have to trust the BAM guys to sign and give it back, but if everyone signed it at a court date, that could make so much. Maybe reach out to CRL. I don't think the BAM guys would sign it, but like Ben and them could. Dina Kawaji, thank you for the 5 gifted memberships. I'll reach out. I'll ask. Donnie Not Wahlberg, thank you for your case coverage. Thank you. Katie Hewling, regarding the auction donations, can we donate stuff to the auction, but hold on to it so we can ship it ourselves and save you some shipping costs? If yes, what's the deadline to email you about it? End of September, I think, and I think that could work. So yes. Sandy, thank you so much, and thank you again for the 5 gifted memberships. Lily Sophie Jack, thank you for becoming a member. Welcome aboard. Nurse Thale, Runkle, have you tried a Beta beer brewed here in South Louisiana? No, I've never seen that carried anywhere. They have a variety pack I'd like to send you. Strawgator is the best. That sounds delicious. You'll have to look up the rules on sending booze across the border, though, because it's tough. So, Michael Garrison, need a beer? Yes. Also, the Seattle thing. I will post pictures. You guys are going to lose your minds. Sandy, I need to hear this story. It was an epic adventure. In loving memory of Runkle's mud bathing car. The wonderful thing is that it actually is running great. Happy Monday live stream to Runkle and friends. Happy Monday. After Colonel Mustard in the library with a candlestick, we now have Poot in the courtroom with a gun. Yeah, he makes choices. Honk Banana, no. There's rumors circulated about the bemuddled Runkle-mobile. Please update and lay those rumors to rest one way or the other. It is rescued. My Sunshine says, live south of Seattle, used to work for Port of Seattle, including SEA, and also work for airlines. Let me know if I can be of any help. So basically, I'm going to land in Seattle. And then at some point, I am going to take a little puddle jumper plane, a little tiny plane. And then, so I don't know if I've got enough time between the landing in Seattle. Like if I have a day between the two, I'll do like an evening meetup and then, fly out the next day. If I don't, then not so much. So yeah. B is for Bob. I can't believe we have to deal with this guy again. Becky should be in jail. She should. With how badly Alex testified in the first trial, do you think he'll testify again? I think he wants to. I think he's crazy. Yeah. Honk Banana No. Motion to rename SLED to South Carolina Analysis and Tracking, just for the more appropriate acronym. Trakushan, happy Canada Day. We are flying to Saskatoon tomorrow. Enjoy. The KKF says, I'm not opposed to him having a laptop with curated information discovery on it. It's better to err on the side of caution in favor of the defense to a point, and that will help keep a legitimate issue out of appeal. Yes. Though it sounds like they're just going to send like a clerk or whatever. NPVIS Queen, can South Carolina use Alex Murdaugh's testimony from trial 1 and trial 2, even if he doesn't testify this year? Sorry if this is an easy question. The uses of testimony from the first trial are complicated, but it's not just like we take the testimony and apply it to the second trial. It doesn't work like that. But they might be able to, for instance, cross-examine him with regards to, differences and so forth. So, yeah. But they can't just take his testimony and then dump it in. Sandy 136, he had his computer privilege taken in August 2023 because his defense attorney recorded him reading his journal entries over a call, which was then provided to the media for an upcoming documentary. That's bad. Chelsea Rama, why do you think the retrial will take longer than the first? I mean, I suspect they're going to fight it harder. I suspect there's going to be more experts. Didn't Sarah Boone have this problem with the laptop? It was held by prison staff and she had to ask for it. They put aside a conference room for her to use the laptop, I believe. Yes, there was a whole big chaos about that. B is for Bob. He looks a lot different than he did 3 years ago. Yeah, he looks like Frankenstein's monster. Overturned life without parole for minors. 16 years working in a men's prison. Also, your security level generally doesn't have anything to do with your crime. Murderers are level 1s all the time, and they're generally the best behaved. Yes, that is true. Catherine Fraser, can we get to innocent until with Murdaugh? I mean, they gotta prosecute him, right? Wouldn't a change of venue benefit both sides? I feel like it benefits the defense more, but it should happen. Beamer, make it a double, thank you. For the whiskey goal, thank you. Bird Mad Girl, thank you for the 5 gifted memberships. Crystal Dagger, whiskey for Runkle, needed after listening to Poot. Poot is something. Bird Mad Girl, Runkle, are you getting this bonkers heat wave like Michigan this week? Also, I want to thank you again for your coverage on the Uvalde trial. Right now, we're getting a lot of rain, which has been limiting the heat, which is good because the heat is bad. So this is my office right here. Mrs. Runkle's home office is there. They have one circuit between them. I have an AC unit, like a little portable AC unit. It's it helps keep me sane when the heat is on. Mrs. Runkle also has a little portable AC unit. If we both run the AC at the same time, it pops the circuit breaker. So, yeah. The other fun thing is that the garage where my leatherwork stuff is, I have an AC unit there. But it's hard to use because in order to properly use the AC unit, you've got to vent the heat somewhere. And so the way I set it up is there's a furnace in there. And so what I do is I set it up to vent I hook the AC up to the furnace so that it vents out the furnace pipe. It's really not ideal. So I want to get back out there. When's the last time you were in the garage leatherworking? Like 2 days ago or yesterday, was it? So I've been trying to get back out there. So yes. And also I want to thank you again for your coverage on the Uvalde trial. That was an interesting trial. It changed my mind. Poor judge never had asked to receive Dick Poot's motions. The Miss Monty, thank you so much. Horse welfare really needed this comic relief today. I wanted to thank you, chat, and the Pup Swoops for brightening my day. Oh, there's going to be some additional comic relief because, yeah. Kim Carter says, tough night tonight, virtual hugs. Virtual hugs. I don't know what's going on, but I hope it works out there. So, yeah. After surviving a summer in Mindanao, Canadian summer heat barely registers. It still registers to me, and the garage heats up like an oven. So, yeah. Okay. Was it our stupid landlord town housing took away permission for us to have window air conditioners? It's ridiculously hot. Oh, that's insane. All right, let's look at this. Some of you might have seen this. It is posted online titled 3 Judges Realize Attorney Has No Idea What He's Arguing.
And financing
session of the 6th District Court of Appeal in case number 6D232601, Foreman Electric Services, Inc. versus LSQ Funding Group, LC. We are here today on an order to show cause as to why sanctions, including attorney's fees and costs incurred by the appellee, should not be imposed against counsel Jerome Ramsarin personally, pursuant to both Florida Rule of Appellate Procedure 9.410A, as well as Section 57105 1B of the Florida statutes. All right.
So the sanctions that they're asking for is they want attorney's fees against the lawyer himself. Not like the lawyer's client, but the lawyer personally. And so this is a bad place for him to be. But here we go.
All right. So, sir, what I'd like to start with is, could you please tell us how long you have been practicing law?
This month makes my 10th year in practice.
What area of the law do you primarily practice?
I primarily practice what I would like to call consumer protection mostly. So we do, well, I'll break that down. We do a lot of homeowners insurance claims here in the state of Florida. We do personal injury, actions against banks, lender institutions on behalf of consumers. We have, in the last year or two, begun working with more in the commercial space in the realm of government contracting. We've been dabbling here and there, thus our involvement in this case.
Okay. And how many appeals throughout that practice have you handled?
Maybe more than 10, less than 20.
More than 10 appeals.
More than 10.
And for how long? How many years have you been practicing appellate law?
I've probably been engaged in the appellate circuit. I mean, as far as filing appeals, I don't want to say anything incorrect, but I believe at least for the last 5 years, if not more.
And are you handling these appeals by yourself, or is there anyone who's assisting you?
At the time of this case, there was someone assisting me. A longtime paralegal and former attorney named Tracy Long.
Okay. But you're primary on your appellate cases, is that correct?
Correct.
Okay.
Now that already made me go, wait a minute, a longtime paralegal and former attorney. I'm like, oh, that's interesting. All right.
And sir, have you reviewed all of the Florida rules of appellate procedure?
I'm fairly familiar with them. I won't say I know them all inside and out, but I mean, I know how to, use my resources as needed and to try to comply with the rules as necessary.
Okay.
So far, so good, right?
What I want to do is start with the contents of your initial brief, because pursuant to our show cause order, there are 2 bases for fees, one of which is Rule 9.410A, which is the sanctions rule under the Florida Rule of Appellate Procedure that provides that the court on its own motion may impose sanctions for any violation of these rules or for filing any preceding motion, brief, or other document that is frivolous or in bad faith. So I want to get to the briefing portion of that rule. And I believe that this was raised by the appellee in their previous motion for sanctions under 57105. When I look to the argument portion of your initial brief, What I find are a plethora of citations to sort of, I want to say boilerplate or well-settled rules of law that I don't believe either party contends aren't applicable here. But that's just a sort of broad rule. There's no argument with regard to any of those citations. And so can you tell me about that and why there is no analysis in the argument section of the brief? And I'll tell you why I'm asking you that is because under Rule 9.210B5 of the Florida Rules of Appellate Procedure, that rule requires an argument with regard to each issue that you intend to raise on appeal.
If I may.
So the judge is like, you cited a lot of cases, but you didn't make any arguments. So was that a thing you plan to do?
Hey, may I pull up the initial brief?
Yes.
I wasn't going to be talking about it today. Give me a moment. Let me grab that. Here, are you talking about the initial or the amended?
The amended initial brief.
Understood. So as I go through the brief, I know we have our statement of facts, and we are looking for the section that you're specifically referring to.
I'll tell you why I'm saying this too, counsel. In addition to the rules, it strikes me that the appellee argued in their motion, which isn't before us today, but it's the same reaction, frankly, that I had when reviewing the brief is how would the appellee know what arguments to respond to if you were simply setting forth well-settled points of law?
I see, Your Honor. And I do believe we do flesh this out a little better in our responses to their motions for sanctions. But I do note that even within this, that we do take the position.
By the way, my favorite person is the guy on the right, Judge Mize here, because his facial expressions through this are stellar.
And that, let's see, let me make sure I'm saying this correctly. That this is not law I'm looking at. I'm looking at this quickly, so bear with me.
Counsel, I'm a little surprised that you say you didn't understand we'd be discussing your brief today when the order to show cause specifically said the hearing was about your brief.
He's just like, I'm just going to verbally stab you in the guts. Like, he's just like, are you... That was the judge just going, counsel, are you fucking kidding me? Like...
Respectfully, Your Honor, I thought that the hearing was with regard to the fact that I did not provide a response to the June 18th show cause order.
The order to show cause says why sanctions should not be imposed against him pursuant to Florida Rule of Appellate Procedure 9.41A for, quote, filing a brief that was frivolous or in bad faith.
I thought it was for failing to respond to your order to show cause to that exact issue. Maybe I misunderstood. But with that being said, I
want to hear the judge again.
Imposed against him.
I did not. Respectfully,
counsel,
sure I'm saying this correct. Yes, that we do take the position that, let's see, let me make sure I'm saying this correctly. That this is not law I'm looking at. I'm looking at this quickly, so bear with me.
Counsel, I'm a little surprised that you say you didn't understand we'd be discussing your brief today when the order to show cause specifically said the hearing was about your brief.
Respectfully, Your Honor, I thought that the hearing was with regard to the fact that I did not provide a response to the June 18th show cause order.
The order to show cause says why sanctions should not be imposed against him pursuant to Florida Rule of Appellate Procedure 9.41A for, quote, filing a brief that was frivolous or in bad faith.
I thought it was for failing to respond to your order to show cause to that exact issue. Maybe I misunderstood. But with that being said, I do believe we take the position.
I love the judge's like eyebrows there. He just raises his eyebrows like, okay, like this is some bullshit, but oh yeah.
Within the brief that there is an issue of fact created in these documents that we presented to the lower tribunal here. Specifically, the fact that that this case arises from a standard subcontract agreement, essentially, between our client and a third party named Haleron. Haleron ultimately sold its invoices or line items to another company, LSQ in this instance. And LSQ ultimately, we take the position that by virtue of that invoice purchase agreement and the language within that, and a subsequent action that LSQ, in which Haleron sued LSQ, and wherein LSQ answered pursuant to its answers and affirmative defenses, that there is a cognizable and judicial issue of fact in this case over whether or not we are a third party beneficiary to their invoice purchase agreement.
Counsel, can you tell me two things? Number one,
Yes.
is that the answer and affirmative defenses filed in the other action in our record on appeal?
Yes, Your Honor. It was made a part of the record on appeal. Well, maybe not part of the record on appeal, but via the appendix.
Why is that proper under the rule?
Well, I don't want to say again, Your Honor. I'm not.
And so the judges here are just like, so you did a thing. Can you explain why you're allowed to do the thing? And he's like, no.
Certain. I believe it could be part of the record on appeal because it was part of our third amended, a motion for leave to file a third amended complaint, in which a lot of those allegations were put forth. But I do know for certain that they were put into the appendix.
But would you agree with me? Is there some rule of appellate procedure in your mind that would allow you to insert items into an appendix to an amended initial brief that were not included in the record on appeal?
Is there some rule in your mind? I'm like, oh, fuck. The thing is I don't get how this guy isn't breaking down and crying right now, but he's giving it.
Not that I know of, Your Honor, but I believe these were put into the record on appeal, or at least in the lower tribunal.
That's what I'm trying to get clarification on.
I see. The only reason we would not, or we would file the appendix in a case like that, frankly, is if we put it into the record and the record on appeal didn't produce those items afterwards, which could have been the case as well. Meaning that those items were not made part of the record, although they were filed in the lower tribunal.
Oh, okay. Well, would you agree with me that the rules of procedure in the appellate court require you to have documents that you're going to cite for purposes of the appeal in the record on appeal, not just filed in the lower tribunal? We don't have that before us. I guess this brings me back to the original point, which is if maybe there.
So how do I put this? This is the equivalent of like, so what they're saying is that at the lower court level, the matter that's being appealed, a bunch of stuff was filed, but he doesn't use or reference those in the appeal. And the court is like, those are different courts, right? You know, this is different. And he's like,
is something that would support an argument that you're now making about third-party beneficiaries. And I am wondering what is happening with the argument section of this brief, such that this is raised in here and such that the appellee would have notice that is your argument, that you're relying on the answer and affirmative defenses raised in the other action. And can you show me in this brief where the appellee would be put on notice of that, and not simply, I know that was a part of your argument in response to the show cause order. That's separate in my mind because that's far later.
Understood. Paragraphs 8, 9, 10, 11.
What document?
Of the amended initial brief. 8, 9, 10, 11, 12.
What page are you on, counsel?
4, 3 and 4.
Okay, sorry. This is just about the argument section.
I see.
Counsel, you seem there's two different issues here, and I think we're trying to get you to address one and you're addressing the other. So there's the merits of your claim and whether or not you all had an argument you could have made that wasn't frivolous. Okay. Then separate from the merits, there's you complying with your obligations as appellant's counsel to put those arguments into a brief. So before we get to the kind of merits of whether or not you could have had a claim, right, and whether or not the trial court did in fact err, you had some basis to dispute that. I think the issue is you wholly failed to articulate an argument in your brief, even assuming you had one. There's just no argument at all. The argument section that you have labeled argument is just kind of a cut and paste from various rules and cases, with no explanation whatsoever how any of those authorities, make an argument, why the trial court would have erred according to those authorities. There was just.
He's like, you gave us citation soup, and there's no argument. Like, you haven't made an argument is the most basic shit here.
No serious attempt to meet your appellate burden. So it's not really the merits of your claim we're at this point, although I looked at them and it does seem the claims were frivolous. At least it's hard to completely evaluate what argument. Just looking at the record, it's very hard to see how you could have made a meritorious argument. But we're not even there yet because we're just talking about contents of your brief.
He's like, I'm sure your argument is bullshit, but you didn't actually make it. Oh, yeah.
And the complete failure to include an argument section and to comply with Rule 9.210, requiring you to set forth arguments on each point of appeal. You had 2 points of appeal. There was no argument section. There was nothing in your argument section to support or put forth an argument on those 2 points of appeal. Do you see the distinction I'm making?
I do, Your Honor. I see it's more, substantive as to what's in the brief itself. Let me see.
I'll tell you, I did, in terms of the order to show cause, I did just look again, and the you had the order to show cause explicitly said this was about your brief, and the hearing order that we entered setting this hearing said this is why the hearing is about why sanctions should not be entered for the reasons stated in the show cause order. So everything you were put on notice of today explicitly said the brief.
Understood, Your Honor. I mistook that. I thought the court was upset with me for not directly responding to the June 18th order. All I can offer the court is this, that the case law that we cite goes to the arguments that were made, and albeit they were not made in the argument section, they were made in an earlier section, but they go to the heart of those arguments that I referenced earlier. Let's see here on page.
Is there any part of your argument section, Mr. Ramshaw, that you can point to and say this made an argument?
No. The argument section.
This is killing me. Is there any point of your argument section that you could point to and said this made an argument? And he's like, no. Oh man, I gotta see that.
On page.
Is there any part of your argument section, Mr. Ramshaw, that you can point to and say this made an argument?
No. The argument section recites certain case law.
So do you agree your argument section included no argument of any kind?
Yes. I mean, except for page 17 where we give a summary of the argument.
Counsel, in your response to the show cause order, it's not in your personal response. It was in the one filed on behalf of your client. You argue that sanctions would be inappropriate because you have a valid argument for the extension of the law. And in such a case, sanctions under 57-105 would be inappropriate. Is there somewhere in this brief where you ask us to extend the state of the law to incorporate your facts?
I'm not understanding the question.
Is there any argument in your initial brief for the extension of the application of the legal authority that would presently govern this lawsuit?
I mean, we cite the areas of the law that we believe support why the court should have what was incorrect in denying our motion to admit the third amended complaint, and why they were incorrect as to dismissing the action with prejudice. I mean, I believe those recitations stand for that proposition.
This is like the parents sitting around listening to a toddler's explanation of what happened to the cookie jar. right? Like,
You see,
Which part of the argument section did you explain why the trial court erred in dismissing the Second Amendment complaint or denying leave to file the Third Amendment complaint?
that would have been in the earlier section where we recite kind of the history of the case.
Okay, so you had a statement of case and facts that says the trial court dismissed it, and then you have an argument section that says nothing or doesn't contain any argument.
Yeah, I think
So
we kind of went about apologies. Sorry.
Which part of the brief would you say explained or provided some type of argument as to why the trial court erred?
I would say that the section that comes before the summary of the argument, we kind of put our arguments within that area and in response to the facts and put them forth. We kind of take position at that
Counsel, is it your understanding of the Florida Rules of Appellate Procedure that you are permitted to make argument in the factual background section of your initial brief?
No, Your Honor, but I didn't think it would be inappropriate to do so. I mean,
no, I didn't think I was permitted to do it, but I didn't think it would be appropriate to do it. It's like, if you're not permitted to do it, then it's inappropriate to do it. Okay.
This was not
to put argument in the facts section.
Well, I mean, we did put the arguments there as we set forth the facts. We stated our position on those facts, and I believe that what follows supports those positions.
Counsel, do you agree that the trial court's order comes to us with a presumption of correctness?
Yes, Your Honor. I never thought about.
This is trite law. There is a presumption that previous courts were correct. That can be overturned, but you start from the point that the previous court was correct. So this is like they're asking him this is the kind of question that if you're getting asked is imagine you walked into the mechanic and you asked the mechanic a question like, well, you'd agree that gasoline only goes in the gas tank, right? It kind of suggests that there was a pretty serious fuck up going on. So, yeah.
But yes.
And so I share what's, I think, clearly been articulated by my colleagues, and what we were struggling with is if we have a trial court renders an order and it carries with it a presumption of correctness, and then it comes up to us and we have a brief that contains no argument. We have that brief based on things that are outside the record, contrary to the rules. And we also have an absence of a transcript. When the order that is presumably correct specifically says, for the reasons stated on the record, it was dismissed. So explain to me how that, all of that taken together, would be a good faith appeal.
See, this is the point where what he should be doing is falling on his sword and going, Your Honor, I fucked up. This is, and he's like, because, yeah.
In this case, Your Honor, the lower tribunal did not articulate reasons. We say that within the recitation of facts section. It did not give reasons or
His order says that he stated it at the hearing.
And just saying that there's no reasons, you got to provide the transcript for the reasons or to show that there weren't any.
Judge Falcone wrote, one moment, please. Judge Falcone wrote, for the reasons stated on record, LSQ's motion to dismiss is granted. Foreman's second amended complaint is dismissed as to LSQ with prejudice. For the reasons stated on the record, Foreman's motion for leave to amend is denied as amendment would be futile.
But Your Honor, in this case, there was no transcript or anything of that nature in this case. That we have no record of what was stated at that hearing.
Counsel, it's your burden to demonstrate that the trial court erred in dismissing the complaint. Is that correct?
Yes.
Okay, so I think this goes back to Judge White's question, which
They're basically like, counsel, this is elementary law school stuff. Like, do you know this? Do you know the basics?
I interrupted when you stated that the trial judge did something to the effect of he did not put something on the record, or he did not state it at the hearing. Let's call it stated at the hearing. There doesn't seem to be a record.
Well, my only point was that the order did not include the findings from that hearing, or did not include the reasons.
So you're saying he did state it at the hearing orally, but it did not put it in the written order?
I mean, as I sit here before you today, I can't even recall if he did or not. We felt the reason we filed the appeal is we felt.
Dude, you came to this hearing for the sanction hearing to decide if you're going to have to pay a whole fuck ton of money. And what do you mean you don't know? Like, what do you mean you didn't check?
We weren't given a good reason as to why it was dismissed.
Is there something under Florida law that requires the trial court in this sort of action, given the claims that were raised in this particular case, to make affirmative findings when dismissing the case with prejudice?
I was under the impression that the trial court has that responsibility when a final judgment.
Based on what authority were you under that impression?
As I sit here before you, I don't know it.
Wouldn't that have been something important to determine before you filed an appeal?
Respectfully, I didn't know that this was going to be an issue in this type of regard.
Oh man, the judge is just like clowning this dude.
We filed.
You just said that you thought the trial court erred by not putting written findings in an order, and then I asked you from where, and you said, I don't know. So if you're filing an appeal thinking that the trial court erred based on not including written findings in an order, isn't that something you should look into and determine you're right about, or have some legal basis to think before filing an appeal and having us spend resources on it, the opposing party spend resources on it, that could have been spent on a meritorious appeal?
Your Honor, I'm not trying to be difficult.
Why are you filing this appeal and making us waste a bunch of time that we could have spent on something with value? Oh man, that is pretty close to apologize to the plants for the oxygen you're using.
I don't think I'm understanding the question.
You told me, counsel, that the trial court erred by not putting written findings in the order.
Yes.
Correct?
Correct.
Okay. Then I asked you why you thought that, from what authority, and you said, I don't know of any. And so what I'm saying is, if you're going to file an appeal thinking that something was an error, shouldn't you have some reason or legal authority to think it was an error before you file the appeal?
Well, I believe we do address that on page 5 of in the statement of facts. We state that the lower trial tribunal did not articulate any specific deficiencies.
Counsel, that's not the question I asked you. I'm not asking whether you said he didn't articulate reasons. I'm saying whether you had any legal authority to show that he needed to articulate reasons.
No, but respectfully, that's not an issue that we raised in this complaint. Or in this appeal.
Well, you just told me that your argument is within your statement of facts. That's what's in your statement of facts. And then you tell me that you just told me a few minutes ago, the three of us, that the trial court, you believe, erred by not including written findings in his order. Do you see why the absence of any argument in your argument section would make it hard for us to figure out what your argument is?
I'm starting to see the struggle you guys have had with this.
Counsel, I'm going to get back to a question.
No, you don't need to see the struggle that the judges have had with this. You need to see the struggle you are having with this, because the struggle you are having with this is the issue. Oh my God.
Asked before that wasn't clear. In your response to the show cause order, my understanding from reviewing the response, and it's the latest response, is that 57105 sanctions would be inappropriate in this case because, quote, the appellant believed it was asserting a good faith argument for the extension of existing law based on such cases, and then you quote cases. So is there somewhere in this brief,
I
and
felt like
maybe
Mr.
for some
Fowler could
reason
use
it would be
one
in this
too.
fact section, but is there somewhere in this brief where you could tell me that there is a good faith argument made for the extension of existing law?
Yes, within the argument section, which you guys say is a recitation of law. Let me pull it up.
Counsel, if you think there's some part of your argument section that is not just copying and pasting various, items of law, please point it out to us, because we're not characterizing it that way. That's in fact what it is. That's not our interpretation. That's exactly what it is. There's not a word of argument in the argument section. There is just copying and pasting from various rules and cases with no explanation of any kind how any of those authorities apply to this case or demonstrate that the trial court committed error under the facts of this case. If you said, well, that's how we characterize it. If we're mischaracterizing it or characterizing it incorrectly, feel free to point us to the section of the argument set, the page of the argument section that you think does contain argument.
I'm looking right now. I just pulled it up, page 23. Refusal to allow an amendment is abuse of the trial court's discretion unless it clearly appears that allowing such amendment will prejudice the opposing party. The privilege to amend has been abused or amendment will be futile.
Okay, so copying and pasting authority, we got that.
Yes, but again, that relates.
Oh my God, this guy is this is ridiculous.
To earlier arguments made in the brief, not necessarily within that quote unquote argument section, but relates back to other sections where we take a position that we should have been allowed to amend.
But there's nowhere, it strikes me that there's nowhere in the brief where it says why you should get an opportunity to amend. For example, Judge Falcone erred in finding X, Y, and Z, and then walking through the factors that lean toward permitting a party to amend. There's no moment where you say why he erred. Maybe he got futility wrong. It just strikes me that there is nothing, at least at a minimum, not in the argument section, that tells us why he erred. Where is the demonstration of error, which it's your burden to do?
He gave no reason as to why amendment should be disallowed in the case.
I get it. There's a place in your statement of facts where you say he didn't give a reason. Okay. Mm-hmm. But in order for that to constitute an argument, we would need some kind of match between a statement of facts and law, and then applying that law to facts, right? That's how arguments work. So
that's how arguments work. Oh, fuck. Oh man. How is this guy not just turning into a puddle right now?
For instance, and then we would give a reason. Okay. But in order for that to constitute an argument, we would need some kind of match between a statement of facts and law, and then applying that law to facts, right? That's how arguments work. So for instance, there's nothing in your argument section giving us any law saying he needed to give facts, and then saying, hey, look, in my statement of facts section, I pointed out that he didn't give those, and that's what the order says. It's missing those facts. Here's the law that says he was required to give those findings or reasons. Therefore, he erred. Do you see how that kind of thing is totally missing?
Absolutely. And yes, we don't have that cadence of an argument, but I believe those pieces are there. It just
is there a piece where you give us some authority for the proposition that he needed to state findings in his written order?
Let me pull back up number 20, page 23. I thought I saw something there.
Counsel, there's not, because he doesn't. That's not.
He's like, counsel, stop looking. It ain't there. Fuck.
Not a thing.
Well, we cite
trial judges ruling on a motion to dismiss are not required to make written findings in their order. You won't find that because it doesn't exist in the state of Florida. That's not a thing we do here.
Well, I understand, but there's a case we cite to Carrila v. Jean D. and Catherine T. MacArthur. Ordinarily, dismissal with prejudice should not be ordered without giving the plaintiff an opportunity to amend defective pleading unless it's apparent that the pleading cannot be amended to state a cause of action. No such finding was made that this was.
He found it was futile, counsel. He made an express finding of futility, Judge Falcone did, in his written order dismissing the operative pleading.
But that's exactly what we're arguing against. We're arguing that this is not futile. Maybe he just missed.
So futility is basically there's no point giving them permission to amend because there is no amendment that would save this, right? It's just, it's so bad, right? So like imagine if I sued Bob and my allegations against Bob were that like, I'm suing Bob for being excessively ugly. And they'd be like, yeah, there is no way to amend this that actually turns it into a legitimate claim. So we are not allowing you to amend it. It's just gone.
Understood our cause of action or what we were trying to do.
But how do we know he misunderstood it when he referenced, and Judge Mize is correct, he doesn't have to make written findings in the order. He says, which is presumably correct because it's in his written order, he says, I gave my reasons. You're not suggesting that in the absence of a transcript that you satisfy your burden just by saying that a judge actually did not state reasons on the record?
Not at all. No, not at all. We're just saying, our only position is that yes, he made the finding that it was deficient, but our position is that it's not. And therefore, that's why we were trying to amend the complaint. But we believe the amended complaint we put before the court satisfied those deficiencies.
Counsel, let me ask you about, I'm a little puzzled about your filing, this amended response that Judge Brownlee referred to that you filed on the 25th of this month, amending your prior response. And it starts out, it says appellant, Foreman Electric Services, and undersigned counsel. That was one of your amendments because, as had been pointed out, it didn't appear to us that you would have filed it on your own behalf in addition to your client. So you corrected that. And then, but on the last page, however, your signature line, it says underneath your signature block, attorney for appellant, contractor litigation financing LLC.
I probably copy pasted that signature block. Apologies.
Okay, so that's just a typographical error, or does contractor litigation have some interest in this case?
None at all.
Okay.
Counsel, did you proofread the brief before you filed it?
Now he's asking that question, but the answer is no.
This brief, yes.
Because there's a lot of things in here that are like, even in the statement of facts, either obvious misstatements or otherwise mistaken. You tell us there's a U.S. District Court for the Western District of Florida. That obviously doesn't exist. You make a lot of statements about like at all material times there too, but then you make a statement that kind of by its nature cannot be done at all material times there too, like something that happened on a specific date. Like you said, like at all material times there too, the parties entered into a contract, or at all material times there too, a particular pleading was filed. Things that by their nature don't happen at all material times there too, that happen at a specific point. So that kind of made it hard for us to even follow the statement of facts because it just large parts of it were nonsensical.
I see. The reason we put that statement in at all material times, we were trying to point the court to the pertinent facts that upon which we're basing our arguments.
But what I'm saying is when you say at all material times there too, for numerous statements, and it wasn't just once or twice, it was a bunch of and then what follows is something that by its nature doesn't happen at all material times there too, right? So like if you say at all material times there too, someone had a duty, right? That's the kind of thing that can happen over a period of time. And it can make sense to say that duty existed at all material times there too. When you say at all material times there too, they filed an answer, or at all material times there too, someone entered into a contract. Those are things that by their nature happen on a particular date. They don't happen at all material times there too by their very nature. And you kind of
So Judge Mize at this point is just dunking on this guy. Because, yeah, I mean, the language of on all material times is used a fair bit in law. But as he points out, it's used for things that are like long lasting, right? So like at all material times, Runkle was a resident of Alberta, right? You know, I lived in Alberta. I stayed there the entire time. There's no, you know, whatever. But you can't be like at all material times, Runkle died. You know, like that doesn't work.
Did that throughout the brief, throughout the statement of facts section.
I see. I use that to state that at all times, you know, that are material to his action, you know, Foreman did enter into a contract. I'm looking at right now, I'm looking where I see that.
You can say at all material times they had a contract, but you can't say that he entered into the contract at all material times because that's a specific time.
On page 8, you know, for example, where we say at all times material here too, Foreman submitted the 5th invoice to Halloran for materials and labor.
Well, that's what I'm saying. Can you submit an invoice at all material times throughout a dispute, or do you submit an invoice at a particular time?
Well, at a particular time, but in reference to this action, what we're trying to say here, that we're trying to say that this is, you know, this is a pertinent fact, and maybe there's a better way I should have said that, but that's what we're trying.
Yeah, maybe there is like an accurate way. I feel like this guy got his arguments from like an early prototype of ChatGPT.
To say by way of that introductory remark.
Counsel, if we were to conclude that this brief was frivolous or in bad faith, what do you believe the appropriate sanction would be?
So when the court asks you a question like that, if we were to find against you in this, what do you think we should do? What it means is we've pretty much decided your filing is frivolous and it's in bad faith. How, like, let's move on to punishment. How hard should we spank you, sir? And yeah, that's a bad thing to ask when it's about whether it's frivolous or bad faith.
I mean, I would ask this court not to monetarily penalize us. I don't know what other sanctions or options are available. This is the first.
Referral to the bar, dude. This is the time to write. I would ask this court not to monetarily sanction us. I don't know what other sanctions. Monetary sanctions are the least of the sanctions. This is the time, sir, when you stand up and say, well, we will, you know, we'll obviously pay, like, you know.
First time I find myself in a situation like this.
Counsel, after hearing from us, do you think the brief had any merit? Not your claims, but the brief.
I believe the brief has merit, but I think it could have been written much better. And albeit I didn't write this necessarily, it was my responsibility and I oversaw it and I filed it. With that said,
who did write it?
My assistant. He prepared it. I looked it over. I granted it didn't follow.
So now he's saying he didn't write it, but he signed it. You still own anything you sign.
All the standards of our argument standards, but I thought it made sense.
Is your assistant a lawyer?
He was a lawyer at one point in time.
Okay. Well,
was at one point in time. Did he stop being a lawyer because he's a knucklehead? Like, you know, because what I'm seeing from you, sir, is a gentleman who had cartilage grow out of his neck and continue growing until it was the shape of a head, vaguely, and
is he a disbarred lawyer?
No, not at all. He retired lawyer.
Why was the amended initial
was he retired because he was disbarred, or
brief filed so far out of time after our order?
Your Honor, to be honest with you, we've just been having, and it's not just with this court, we've been having trouble getting these notifications.
You don't get them via email?
It has not been coming to us via email. We've been getting them via mail.
You weren't getting the emails, and now's the first time you're. Oh shit. Okay.
Some of them come in the mail, and I'd have my assistants, pull up, run through our emails or spam, and we can't find those initial because they don't come through the normal channels. They come through something else, something like in the Sixth Circuit, especially some kind of mail.
What do you mean by the Sixth Circuit? You mean the trial court?
No, the Sixth District. I apologize. The Sixth District. They especially come in a different manner than we're used to. I forget what it's called, something case mail or something like that. The orders come through, and they had been going through our spam folder for a period of time. These case mails.
Yeah, whose responsibility is it to check the fucking spam filter for this shit?
And ultimately, they haven't been coming through the e-filing portal, which is typically how we get orders and not saying you guys are wrong or we're right or anything like that. That we overlooked that. We didn't realize that these.
I'm just going to give you a little pro tip for any lawyers or would-be lawyers out there.
How we get orders and not saying you guys are wrong or we're right or anything like that.
There are many different ways to refer to a panel of judges. You guys is not one of them. And especially you guys is not one of them when the panel includes a woman. Like, I mean, this is like one step from, hey, bro. You guys, all right. He's making some choices.
That we overlooked that. We didn't realize that these notifications were coming through something called case mail rather than through the e-filing portal.
Do you think that's something you should bring to our attention?
I believe we did. We notified whoever when we realized we were filing late. We spoke to the clerk or whomever, and we were instructed to simply file at that time.
I think maybe what you're referencing is the fact that trial courts, that you get served with items in trial courts in a different manner than you do with appellate courts.
That's true, but even the third district, like an order will come through the e-filing portal, not necessarily through this email platform that is coming through on the Sixth District Court of Appeals.
Counsel, is this the first time you've ever practiced before the Sixth District Court of Appeals?
Yes. Not my first time in Orange County trial court, but yes, before the Sixth District the first time.
Was there any moment where you tell us, let's see, the order requiring an amended initial brief states that the appendix to the initial brief does not comply with Florida Rule of Appellate Procedure 9.220C. It wasn't bookmarked, and to file a corrected appendix within 10 days. And well after 10 days, that gets filed. So did you ever tell us the reason that you were filing out of time or ask us to accept something as timely filed or anything to that effect?
No, I did not, Your Honor. I did not.
So there comes a time when you have to file something late. And when you do, you need to ask permission. You need to ask the court to allow it. And so what's happened here is he's like, I'm late. I'm just going to file it and just like, that's fine. And here's the thing. If you do that, the most likely outcome is that the court just throws out your late filing. Like, yeah. And yeah, usually you need to ask permission before you're late. Like, you ask permission while you still have time, but you know you're going to be late. And that's, yeah.
File anything requesting that be taken in or anything of that nature at that time.
All right, and counsel, when I look at the appendix that was filed, well, let me make sure that I'm on the right one here.
So who is Kevin Fowler and why isn't he talking? Kevin Fowler is the other lawyer. And the reason why he's not talking is because right now the judges are curb stomping his opponent. Like, they have Mr. Ramsaran on the ground. They are kicking his teeth out and they are sweeping them into a storm drain just to make sure that he can't replace them with a timely dental visit. So Kevin Fowler has no interest in interrupting this. It's like, oh, the judges are kicking the shit out of my opponent. I'm just gonna let this go. And the thing is he's doing a great job because he has one real task right now, and that is not to smile in a way that gets the judges interested in him. He is poker facing. And you know what I think he's probably doing? He's probably reading other files right now just to, just in order to like make sure that he doesn't smirk, because you don't want to smirk and get them interested.
Did you do an appendix to the amended? Yeah, you just call it, you don't call it amended, but you'd call it the appendix. So it has the same name as the original one. Okay. So in it, you cite, or you include rather, the subcontract agreement with Haleron Power LLC. Is that included in the record on appeal?
I believe it is, Your Honor. Let me double check.
We're going to go through all 5 items. So you might want to pull up that record. The appendix is.
She's like, this is going to hurt. So you might want to wear some, or you might want to like get some lube here. So
if you're going to do an appendix to the initial brief, certainly and bring our attention to documents, those documents in accordance with the rules have to be included in the record on appeal, or else it would not be proper for us to view it.
Understood. We're just looking at the index to the record on appeal right now. We see that the motion to amend statement of claims third is part of the index. If that's the case, I would represent that the third amended complaint with the attachments are before the record.
Sorry, you mean the subcontract agreement is included in the record as an exhibit to that document?
To the third, yes.
Okay, what about the Texas case?
I believe that's also in the third amended complaint. I'm not sure, though. We make this the third amended complaint is where we make those arguments to try to address the deficiencies that the appellee brought up in the lower tribunal in the lower court. So that's where we try to make our arguments, and it's honestly, it's by virtue of that, the existence of that document, why we believe that the case was incorrectly denied with prejudice.
Okay, so with regard to all of the documents included in the appendix, the notice of removal, the second amended complaint, obviously that would be included, I would think, in the record, and then the settlement agreement and release, all of those are included in the record on appeal?
As I sit here, all I have is the index, but I believe so, yes.
Counsel, the Texas case, without going through every single page, is 63 pages of documents in your appendix. The third amended complaint in the record with all attachments is only 57 pages. So it's not, without going through each page, it's not possible all those documents are attached to the third amended complaint.
Okay. No, I see what you're saying. I mean, I know for a fact we do mention it within the third.
So the question Judge Brownlee asked is, are the documents in your appendix, are all of them in the record on appeal, or are there some that are not?
I mean, I'll have to say I don't know, because...
Was that something you were required to verify before filing the appendix?
Yes. But whether it's in there or not, at least as to their answering affirmative defenses, LSQs, we do cite that case and reference that case expressly.
Counsel, is it appropriate under the rules of appellate procedure for you to give us documents outside the record?
No.
Judge White, Judge Mize, do you have any further questions for appellant's counsel?
No.
Mr. Ramsaran, sorry, Judge White, excuse me. Mr. Ramsaran, is there anything, any final point, anything that you want to tell us in an effort to avoid sanctions in this case, either under the rule or under the provision of the statute that we cited, and given what you've heard today?
I mean, I can say, at least pursuant to 57105, I believe that we've cited some cases that bear similarities to our own. I would argue that the cases that we cite to were actually weaker than our own, because our case actually is supported by facts and evidence. Particularity comes to mind is the Coretta trucking case. I have a lot of documents open right now on my laptop.
Oh, good. That's helpful. Lots of documents. Helpful.
In that case, Coretta trucking, both cases involved decisions where a lower tribunal dismissed the party's actions with prejudice. And the Coretta trucking matter, the appellee disparaged the appellant's efforts to assert a claim for breach of contract as a third-party beneficiary and argued that the appellant was once more asserting its claims and amend its complaint.
Dude, at this point, you should just beg. Like, beg for mercy.
Following prior dismissal. In this case, LSQ is arguing that the invoice purchase agreement doesn't create a contractual duty to discharge senior liens in the case.
It says authorized, right?
I'm sorry?
Oh, hey, good to see you.
I'm sorry, what were you saying?
Great video on the...
you were making the argument that they were required to pay off the liens, and the contract.
Well, they were arguing the contrary.
Excuse me, counsel. Excuse me. Sorry. The contract specifically says the word authorized rather than obligated, correct?
Yes, Your Honor, of course. But we believe that by virtue of the invoice purchase agreement, their response and their answer and affirmative defenses, and our subcontract agreement taken as a whole, it could construe a situation where we have a third-party beneficiary relationship under a contract, by virtue of the fact that, and I think I break this down a little better here, viewing LSQ's third affirmative defense in conjunction with paragraph 11 of the invoice purchase agreement, appellant contended and continues to contend, and the third amended complaint that there's sufficient basis to assert a cause of action for breach of contract against a third-party beneficiary. Stated differently, LSQ made prior representations that LSQ and Haleron came to a meeting of the minds at the time of forming the invoice purchase agreement, whereby LSQ agreed at the behest of Haleron to pay all monies owed to certain contractors, including former electric services. And if that was proven true, it may be sufficient to demonstrate the language contained in paragraph 11 of the invoice purchase agreement was, and I won't use the word at all times, but that it was intended for the primary benefit of former electric services.
But counsel, if I could ask you, sort of circling back, do you understand that we could find, just for the sake of argument, we could find that maybe you made a non-frivolous argument before the trial court, but that brings us back here with the rules and the requirements of an actual argument in the brief, the requirement that prohibits you from providing us with documents outside the record, and your failure to provide a transcript, which would perhaps show us, or you're aware that the rule also allows you, in the absence of an actual transcript, to work with appellee's counsel to reconstruct the record before the trial court. Are you aware of that under the appellate rules?
No, I am now. Thank you, Your Honor.
Okay. And so...
Oh, man.
So tell me how your cases, which of your cases, and I looked at all of them, I don't recall seeing a case that dealt with an issue of whether an appeal is frivolous. Which cases do you believe would support your request that we not sanction you for a frivolous appeal?
Understood. I don't believe I cited to anything of that nature, Your Honor, in my response.
Would you like to make any sort of argument or response as to why we shouldn't sanction you for a frivolous appeal?
Yes, Your Honor. I mean, I would argue that, at least as far as the amended brief, and granted, you know, I've been fully briefed on the deficiencies and the problems with that document as of now, but I would argue that, although out of place, the conclusions, the arguments, the support, legal precedent, I believe all the components are there to make those proper arguments. We give a recitation of the facts. then we provide our conclusions or our position rather on those following that recitation of the facts. And then what follows from there is support that's intended to support our position or argument. And I agree that it's not necessarily the way I would have drafted it or preferred it to be drafted, but at the time I looked at it, the time I read it, I did not acknowledge or appreciate, well, I guess
how dog shit it is. Like, oh man.
that this type of issue could ensue or that it could be construed as frivolous.
All right. Thank you, counsel.
Judge Mize, anything further? Okay.
This guy is not really understanding why there are vultures outside of his window right now, just kind of staring at him. But
all right, Mr. Fowler, I know that you've been present with us today. We set this for a show cause hearing, sua sponte. There was no request for this. I understand that your client did a separate request for sanctions under 57105 that solely requested sanctions against appellant rather than appellant's counsel. So at this point, I guess to put it in a not so eloquent way, I'm wondering if you have a dog in this fight. We're not trying to ignore you, but we're here on our order today. So, unless there's something pressing that you think needs to be brought to our attention.
There's not, Your Honor. Thank you.
Okay, thank you, Mr. Fowler.
It's like, do you need anything? He's like, no, I'm good. I am happy with everything that's happening here because no, I got no issues. I got no reason to dispute this because, oh man. So I feel like that guy is about to feel the swift boot of the law right on his ass. And, Fowler probably went away to just laugh his ass off about all of this, but yeah. And I saw Barbecue Counselor in the chat there. If you haven't been checking him out, he did some great stuff on the recent removal to federal court. He had some points that I hadn't thought of, and I didn't want to steal his thunder. So I just kind of referred to his video and said, check it out. Because, he's been doing great work. Also, one day I need to take his advice on barbecue because I'm going to be in Dallas later this year. And I've had like barbecue in Edmonton, and it's always been kind of disappointing. And I think that's because it's Edmonton barbecue. So I got to try some actual Texas barbecue and see like, hey, what's the deal there? So that was a weird thing there. And yes, I will try to arrange a Dallas meetup for when I'm there. Yes, I will be in Dallas, and I can try to do a Dallas meetup and get that going there because super chats here. We've got Kimchi, the forensic homeopath. Do pro se's ever get cited like this for not following the rules of professional conduct? Pro se's get given a lot of slack, and it's hard for them to get hammered. Just curious, only half convinced this guy's a real lawyer. I mean, yep. If you're going to Dallas, you got to play the Dallas song. I don't know what is the Dallas song? That's worrying. Horse welfare. Is this no argument lawyer worse than robot lawyering? Yes, it looks like. Kimchi, the forensic homeopath. Is there anything difficult or tricky about identifying legal arguments? Isn't this basically a high school level of literacy? Undergrad at least. Sovereign citizens regularly manage to make an argument. So, yeah. Could use a good smile after a crappy day. What's the most embarrassing thing that's ever happened to you in court? To me personally, probably getting hammered in an appeal, like losing an appeal. So I had an appeal on a hearsay issue. I should have won. I didn't win. But they scheduled my appeal at the Court of Appeal for just before Omar Khadr's matter was to be heard. Now, if you don't know who Omar Khadr is like nationally famous. And the reason why is because he was captured in, I think it was Afghanistan, by U.S. troops. They alleged that he threw a grenade at U.S. troops. He was eventually returned to Canada and alleged that he'd been tortured by U.S. troops and ended up suing for a pile of money. So his matter was in court before, like after mine. So I go in on this hearsay matter, and the courtroom is packed, like packed solid. And they have an overflow courtroom, which is also packed solid. And they have people who are just being told, you can't sit. And the justices say, oh, we're going to hear the matter of whatever first, my matter. And I'm like, fuck. Because if they're hearing my matter first, it means I am dead in the water. There's no way they'd be hearing it before the Khadr matter if they were going to be listening to me at all. So they're just like, we're just getting rid of your thing. And so I already knew, like, I know I am going to lose. Like, I just know it. And I'm like, justices, I believe there's a more important matter before you. And they're like, no, we'll hear yours. And I'm like, fuck. So I'm like, all right. I drag myself up because now I know that I'm about to lose in front of an entire courtroom full of people who totally don't give a shit about the issues in my case. And so they don't have any ability to evaluate whether I should win or not. All they can do is just like see, oh, here's this guy who's a loser. And so I get up, and the only thing I did that was any fun on that one was that I got up and I was like, well, I'm quite pleased to see how many people have a real interest in the intricacies of hearsay law, which gets a laugh through the entire room because, of course, they don't give a fuck about my case. But then I proceeded to go, and I argued my case, and I lost. And yeah, I still am salty about that one because I feel like I should have won, but it was kind of embarrassing. I should set a goal as well to talk about. I witnessed a lawyer have a real bad day, and I'll set that as the story time goal there for that. So yeah. His poor client. Yep. Drink one for me, please. I will. The other one I had that was actually quite embarrassing was that I had an argument based on essentially, like, I called my client up to testify. He told his story, and so we go, and he tells his story, and then the prosecutor is like, can we call rebuttal evidence? And the judge is, of course, like, yes, absolutely. So they call a rebuttal witness who establishes basically that everything my client said was complete horseshit, and just completely destroys my client's case. And so I've just called my client up to the stand. My client has lied his ass off. And then it gets to closing argument. And I'm like, Your Honor, you've heard two sides of this. I'm going to suggest that the Crown has not proven this beyond a reasonable doubt. And I sit down because there was just nothing else to say. Like, it was bad. It was really bad. So, what is it? How's Rob doing? Miss seeing him. I think Rob misses you as well. I think Rob is doing all right, but I hope to have an update soon. Ian, it has been speculated this attorney is in the bathroom. It looks like a toilet behind his shoulders. Kind of did, actually, didn't it? Kind of did. So wait, is this supremely embarrassing lawyering, or is this just normal embarrassing lawyering that is elevated because it's on the internet? No, this is really embarrassing. Bob at least deserves merch for all the slander. I gotta get off my ass and do the Bob merch. This guy needs to shut up and take his beating / berating. He's just making it worse. Yep. Lollian, what insanity did I tune in for here? This lawyer who just has no idea what he's doing, and it just, oh my God. Gerald Manning, thank you so much. Michigan Farm Boy. So now he makes an argument on the merits when the question is, why didn't you do this in your filing? He just doesn't catch on to the problem. And I got to roll this. Court of the Institute of Justice. Thank you so much. Gerald Manning, thank you. And for the lawyer story, I will tell you guys the lawyer story. So great folks. Leto's Law covers and promos them quite often, working hard for the little people. I'll have to check them out. All right. So we got one more case to cover. It is 41 pages, but it is we'll probably skim parts of it. So, what is it? Okay, that's somebody here to market. Then we don't need that. So we got a person here pitching veganism as a marketing thing. They're really in the wrong channel because I'm working on a cookbook. It includes pork recipes. It includes chicken hearts. So wrong channel, dude. Go market somewhere else. All right, let's cover this one here. So this is National Association of Consumer Advocates, Incorporated. By the way, if you see bugs in here, there is a million mosquitoes. Frag, they're awful. Versus QC Clearing, doing business as Polymarket. QCX, doing business as Polymarket US. Various places doing business as Polymarket. So this is Polymarket. Have I made bacon? I haven't made bacon from scratch, if you mean. But I mean, I've cooked bacon. Introduction. This action addresses a pattern of flagrantly deceptive and unfair marketing used to mislead American consumers, including college-age DC residents, to risk their money placing bets on a Polymarket platform. So if you don't know what Polymarket is basically a gambling platform that allows you to gamble on just about anything. Like if you want to place bets on whether like Trump will shit himself during his next speech, you can do that on Polymarket. Like you could set that up, you can place bets. And so people win, lose money on various, different things. And so what they're suggesting here is that, yes, they call it prediction markets. So defendants have used secretive and undisclosed paid endorser spots on social media to raise their profile online. To deceive consumers that they are more likely to make money on Polymarket platforms, defendants have furtively advertised these platforms with influencer videos using a fake Polymarket site. Now, I have not been approached by Polymarket to market anything. So yeah. Cover good document. I can't on a live stream because it's so awful that it will get taken down. So yeah. All right. Why is this? All right. So these are paid advertising videos using a simulated version of a Polymarket platform, which shows social media influencers exploring the platform and placing bets. Viewers are led to believe this is organic footage of the influencer using a Polymarket platform, but the videos actually show fake bets on a fake site. So basically what they're saying is that they're reaching out to various big influencers and saying that they should do videos where they appear to be betting on Polymarket and winning big. But what they're actually doing is they're not actually playing with real money. They're on this fake site where they're guaranteed to win. So, yeah. Defendants have also paid to make their Polymarket influencer ads go viral on social media through a scheme called clipping. Individual clippers create short segments of the Polymarket influencer ads and are paid according to whether they can make these clips go viral, i.e., they're paid by the number of views. Defendants explicitly require that clips of their ads must target people in the US, and defendants instruct the creators on how to drive engagement and retention and make the clips deceptive by design. Defendants' Polymarketed influencer ads give viewers, including teens, the impression that content creators and clippers are disinterested consumers posting authentic experiences. B, content creators are typical of traders on defendants' platforms. C, content creators have placed genuine trades on defendants' platforms. And D, consumers are likely to make money trading on defendants' platforms. All of these representations are deceptive. So, as a general rule, when you are gambling, you are going to lose money. Because the casino isn't there to lose money. And, Polymarket is a casino. They take a cut. So you're going to lose money. You should consider that for anything you're betting on, you're betting against people who have inside knowledge of these things because, yeah. So there is no way to keep that out. In parallel marketing efforts, defendants have aggressively targeted college students on U.S. campuses to encourage students to gamble on their platforms. Defendants have engaged in unfair business practices while marketing the opportunity to place bets on the Polymarket platforms. They have used manipulative forms of advertising to promote their gambling opportunity to college-age Americans while obscuring the odds that these consumers will lose their money. The number of active bettors on Polymarket was approximately 643,000 in April of 2026. In the 3 months of March to May of 2026, the volume of trading on Polymarket.com was more than $26 billion, and the volume of trading on Polymarket US was more than $3.3 billion. Many of the bettors on Polymarket US and Polymarket.com are DC residents. That's being pled so that they can claim jurisdiction, right? As a result of defendants' deceptive and unfair practices, consumers in DC and throughout the United States have been harmed. So, court has subject matter jurisdiction, court has personal jurisdiction. All right. Defendant Blockvertise, doing business as Polymarket, was fined by the Commodities Futures Trading Commission for operating illegally and was ordered to cease and desist offering its services to U.S. residents. Polymarket agreed to block all Americans from using its platform at polymarket.com. So, following the CFTC's actions, Polymarket nominally transferred ownership of the website polymarket.com to a company based in Panama. Defendant Adventure One QSS Incorporated, Polymarket, and Adventure One QSS Incorporated began to geo-block users, stop them from using the platform, if their IP address indicated a US location. So, yeah, they're supposed to not be, using the US, but apparently they're focusing their ads on the US. You can see the problem here, right? So later they purchased other things, which registered as a US event derivatives platform along with their affiliate QC Tech LLC. So following this, they've permitted defendants to offer event contract trading to the US public under regulatory oversight. They began to transact business with certain consumers across the country, including in DC, under the brand name Polymarket US. So began to advertise Polymarket US to the public, including DC residents, in summer of 2025. In August, they announced breaking legal football trading is coming to all 50 states this fall. Defendant Matthew Murdaugh, Polymarket's chief marketing officer, posted on the platform X, "Yes, I was just testing the US app we're about to launch. This thing is butter. Soon." And then he posted, "Heads down, focused on the US app launch in the coming weeks." Was made available by invitation only in 2026 with a wait list. And by mid-May, they stopped requiring a code to join the platform. So it became publicly available. So Polymarket US is publicly available, while Polymarket is not available to US residents. But they say, nonetheless, since at least the beginning of 2025, defendants have intentionally caused effects within and outside DC by aggressively marketing both Polymarket platforms to consumers through advertising in DC and nationwide. So, yeah. Defendants also disseminate targeted marketing and advertisements to DC residents, online and otherwise, with the intent of promoting Polymarket platforms specifically to consumers in this district. Okay, so skipping ahead a little bit, they've got grand opening is this Friday. And they note, basically, they say, in the current marketplace, it is trivial to circumvent IP address geoblocking through inexpensive virtual private networks, VPNs, and other technical workarounds that obscure a user's true location. The impact of straightforward VPN usage on Polymarket.com has been clear since 2022 and become undeniable by 2024. An infamous example was revealed in a recent indictment of a U.S. soldier who allegedly used a VPN to place a bet on the removal of former Venezuelan President Nicolas Maduro. But until recently, defendants were not blocking traffic from well-known VPNs, and defendants still do not use certain stronger geofencing approaches, such as methods that rely on GPS. Defendants' history of lax geofencing policies has produced tangible results. A recent empirical study estimated that between 10.6 billion and 26.7 billion of the trading volume on Polymarket.com can be attributed to users in the United States. So if you're wondering, why are they going after US users? It's because of this. If you're going to gamble, play blackjack, your odds are only slightly worse than the house. That used to be true, except most blackjack gambling now has things, that favor the house. I've never seen any sort of gambling video by an influencer or not been skeptical. I have had gambling companies reach out to me via email to ask me to promote their platforms and so forth. And I have said no. YouTube allows you to restrict certain forms of advertising that appear on your channel. And so they're like, you can restrict alcohol, you can restrict whatever. I allow alcohol ads. I mean, I drink alcohol. I don't think it's, certainly you shouldn't abuse it, but, whatevs. I don't allow gambling ads on my channel. And the reason why is because the alcoholics I have encountered in doing criminal law are far less depressing than the gambling addicts. The gambling addicts are incredibly sad cases. And, Because at the end of it, instead of spending money to consume an addictive product, the addictive product is spending money. So, yeah. So, in sum, defendants have been transacting with consumers in this district via Polymarket.com, despite the CFTC ban, in addition to the recent and ongoing transactions via Polymarket US. So, they say that they have standing. Standing is an interesting issue. And the reason why standing is an interesting issue, 10 years without a bet. Good for you. Good for you. Keep it up. And yeah. So standing is an interesting issue because in order to sue, you need to have something that connects you to the suit or something. And so I was like, where are they getting standing here as a consumer advocate organization? Did they spend money to participate? Nope. The law says that a public interest organization may, on behalf of the interests of a consumer or a class of consumers, bring an action seeking relief from the use of any person or by any person of a trade practice in violation of the law of the district if the consumer or class could bring an action. So basically, the law expressly gives standing to consumer groups. Cool. Cool. This action cannot be removed to federal court. All right. And they cite a bunch of law for that. So plaintiff, NACA is a nonprofit public interest organization. They're an association of attorneys and consumer advocates committed to representing consumer interests. Good for them. Defendants, Polymarket is Polymarket. Polymarket is complicated as a group. They say they operate as a common enterprise. So all of these different organizations work together and yeah. All right, we're going to skip ahead a little bit because I don't really care to cover all of the working together implications. Applicable law, we're going to skip that for now. So, defendants' business practices. Defendants use undisclosed paid endorsements on social media. This case is not focused on whether gambling and gaming laws apply to the defendants. This case is about deceptive and unfair advertising practices. We adopt the terms gambling and betting because these are the most accurate descriptions of the opportunity to make money on defendants' platforms from a consumer psychological perspective. I actually think they're entirely correct. It is, this is gambling, right? Companies that advertise on social media have a well-known obligation to ensure that influencers disclose any material connection they have with the advertiser. Of course, material connections include the fact that an endorser has received compensation for endorsing a product or service. Yet defendants have used deliberately secretive marketing campaigns to raise their brand's profile through ads by paid endorsers that are disguised as organic content. In fact, individual influencers with hundreds of thousands of followers have secretly received thousands of dollars from defendants to post about the Polymarket platforms, and have done so without disclosing their affiliation with the brand. Why is no one reaching out to me to give me thousands of dollars? It's the only sure way to win on Polymarket is to get paid thousands of dollars, but they have not reached out to me. So, defendants have written posts for social media influencers to share, and at times have asked them to promote specific bets. Polymarket's chief marketing officer, defendant Murdaugh, reportedly used a personal PayPal account to send at least $35,000 or $350,000 to content creators between January 2025 and February 2026. The motive is clear. Murdaugh has written that the key to growth is a product people can't shut up about. Why is no one sending me $350,000? For example, defendants released a dashboard to track Doge cuts in early 2025. Political activist Riley Gaines, who received at least $6,600 from Murdaugh, posted about the release to over 1 million followers on the platform X, stating, "This is awesome." The post did not mention a financial relationship with any Polymarket entity or brand or with Murdaugh. And that is a great way to get sued for, like, as an influencer too. Polymarket just launched its Doge Tracker dashboard, which provides live updates on every initiative as it's cut. "This is awesome!" exclamation mark. Make government efficient again. So, graphic C. Similarly, a conservative media figure named Elijah Schaefer received more than $8,400 from defendant Murdaugh at the state and stated of the Doge dashboard release, "Exciting news," and that it would be bookmarked for the next 4 years. This post did not disclose Schaefer's material connection with defendants. However, Schaefer later admitted in a comment on the post that he's a long-term brand rep for Polymarket. Interesting. These, you can see they're like naming and shaming some of these, some of these figures, right? I am being facetious with this. I am being facetious. I turned down more advertising because I don't like it. So, the ads about defendants' Doge dashboard were not an isolated event. For example, Alexander Kaufman, a climate reporter who runs a Substack newsletter, received at least $1,200 from Murdaugh and posted on X about the Polymarket.com odds regarding New York City's Democratic primary. Arash Azizi, a historian who writes for The Atlantic, received at least $3,000 from Murdaugh and wrote in October of 2025, "It's fascinating how Polymarket numbers are a good guide for the direction of events. Before any polls, it saw the rise of Mamdani, for instance." Political commentator Brian Krasenstein received more than $9,300 from Murdaugh and posted the following in October 2025 with no disclosure regarding the sponsorship. "It really is unbelievable how accurate Polymarket has been these last 9 months." Interesting, like, just how much of this shit is getting, is shady shit behind the scenes. And influencer Alex LaRusso, who received at least $18,750 from Murdaugh, posted dozens of times about Polymarket without mentioning his connection with defendants. These are merely examples. The full extent of defendants' secret sponsorship of undisclosed advertisements is not yet known. Assuming this case survives past the motion to dismiss, they're going to get discovery of all of the people who got paid. So, yeah, that'll be interesting. Defendants pay content creators to make videos placing fake bets on a fake site. Defendants have engaged in a clandestine effort to place thousands of undisclosed advertisements on social media platforms such as TikTok, all of those places, and then make these ads go viral among young users in the U.S. Defendants promote their platforms by paying content creators, including dozens of college students or college-age individuals, to make videos of themselves placing bets or talking about Polymarket. Content creators have reported making $2,000 to $3,000 per month on their videos. That would be interesting. What is it? I was concerned it would be a problem when I introduced Ian to Bad Dragon, and I'm relieved it's still a thing years later. One of these days, I will convince Bad Dragon to set up an affiliate program, and I will totally shill Bad Dragon products because it will be funny as hell. So defendants require the creators to use simulated versions of a Polymarket platform to create their videos. An analysis of the videos by the Wall Street Journal uncovered certain telltale signs of the fakery. such as spelling the URL as Polymarket with a capitalized I in some of the videos, as well as other indicia of inauthenticity. Defendant's simulated Polymarket site includes numerous signals that strongly imply the video creator is a profitable trader on the platform. I am hearing a lot of thunder outside. That is fun. For example, defendants take collateral for trades in US dollars, which are labeled PUSD or Polymarket USD in the user's Polymarket wallet. In some instances, the content creator's simulated Polymarket site shows them successfully placing bets of thousands of dollars. It is not possible to place a bet of thousands of dollars unless the user has that amount of money in their Polymarket account. So a viewer would believe the content creator had that amount sitting in their Polymarket account in order to place bets with it. Furthering the duplicity, the dummy site the defendants require creators to use sometimes itself indicates the creator has thousands or tens of thousands of dollars in their Polymarket wallet. So they did an investigative report from the Wall Street Journal, and the analysis demonstrated 70% of the viewers showed the creators placing a bet. Video bets were placed in the aggregate amount of 1.9 million. 118 of the videos depicted creators winning almost 900,000, and none of the video bets were real. So if these allegations are true, this is seriously shady shit. Defendants reportedly exert substantial control over the videos, such as sending creators guidance on what to say and what format to use. A common format is to lead with a question expressing disbelief, such as, "Bro, what?" or "Am I missing something?" with a shot of a simulated Polymarket platform on which the creator places a bet with confetti exploding from the transaction button. Once finished, the videos are sent to defendants for review, and defendants may ask for the videos to be reshot. Defendants pay content creators to create the impression that winnings are easy, and in fact, creators frequently use the term free to suggest the bets will deliver free monetary returns. For example, of the 1,105 videos analyzed by the Wall Street Journal, nearly a quarter used the word free, sometimes explicitly in connection with high-dollar bets. So, wait, what? 223 videos. Bro, if this pattern continues, this is free bread. Is this just free money? If I put $1,000 on Canada to win, is this just free? Am I missing something? Bro, what? Content creators fake not just their bets, but also their wins. For example, the 118 videos described above depicted content creators reacting to events suggesting they had won their trades. But according to the Wall Street Journal analysis, the bets depicted in these 118 videos would not have resulted in $900,000 in wins. They would have led to more than $116,000 in losses. Huh. Whoops. The losses are more consistent with the experiences of defendants' typical users. An academic study published in June found that the top 1% of users captured 76.5% of profits, and that about 69% of all users ended up with a loss. Let's look at that again. The top 1% are capturing 76.5%. That really suggests that you have some insider trading or some like sophisticated data analysis that is doing all the like money pulling, and everyone else are just the source of the money. They're the suckers. So an analysis by the Wall Street Journal reached a similar conclusion and attributed this to the fact that a small number of sophisticated professionals, including firms using massive data streams, are profiting from defendants' platforms at the expense of typical consumers. Defendants use clipping to secretly manufacture virality. We already covered that. We're going to skip. So defendants' library of influencer content includes materials from many influencers who are known to target young audience demographics, such as Aiden Ross, Logan Paul, Clavicular, Connor Sinan, Jacob Nackinson, and Nina Drama, just to name a few. Aiden Ross, for example, is a 25-year-old celebrity influencer with millions of followers. He reportedly has a multi-million-dollar deal with defendants and devotes about half an hour per week on his live stream to scrolling the site and discussing possible trades. So I don't know all of these influencers, but the ones I know are all pieces of shit. So, yeah. The Clippers who repost content can make things go viral. All right. Polymarket official clipping. People who join this campaign and create clips to disseminate on social media can get paid $1 per 1,000 views. Defendants go on to specify that one requirement for this campaign is that in order to be paid, the clipper must prove that the people who view the clips on social media are 60% USA. We want only USA. Defendant's marketing firm has reportedly instructed clippers not to use the term Polymarket in the account name, and even to avoid the use of the prefix poly, as it would violate their guidelines. So, content must feel natural and native to the platform. Do not make the videos feel like ads or promotions. Strong hooks are mandatory, and strong engagement pages will be prioritized. No low quality / slop content, original edits only, no direct reposting from other creative pages. No fake analytics or botted views. So keep posts live for at least 30 days. Recommended editing style, fast-paced cuts, big hooks in the first 1 to 2 seconds. Clean subtitles, captions, zoom-ins, and movement for retention. Native TikTok Reels Shorts editing style. Keep videos smooth, simple, and engaging. So next, they are directed to create a realistic profile that feels authentic and trustworthy. So once they've created a realistic profile, so this is the dirty underbelly. Warm-up process. Scroll naturally on the platform. Do not search anything. Act like a normal user. Search your niche naturally. So they are told how to do this. Okay. Scrolling down further. Defendants aggressively target students on college campuses. By the way, there's a lot of situations where college students have bet their money and end up losing their tuition and shit. Yeah, if the top 1% are getting over 75% of all the profits, that's sketchy as hell, right? So, collaborated with student organizations at university to increase undisclosed endorser advertisements. Worked with a company called Campus GTM that pairs them with college students. I feel like by the time this lawsuit shakes out, assuming that these allegations, have any merit, which of course they haven't been proven, these are just allegations at this stage. But if that is the case, if this pans out, I feel like this is going to be a major expose and is going to end up pointing to a whole lot of different people. Yeah. Also, we're going to wrap up a little sooner. And the reason why I say that is that there is so much thunder and lightning right now. I'm worried I'm going to lose power. Because when I hear this much thunder and lightning, I'm like, yeah, I'm gonna get knocked out. So, defendants have also offered to pay fraternities directly in exchange for signing up users. Invited a delegation of frat brothers from Sigma Phi Epsilon chapter to visit the company's office in New York City. They gave the students pizza and wings along with $10 each to use on the defendants' platforms. So, all right. Defendants use unfair tactics to promote their platforms to college-age users. It feels like they're just trying to suck the money out of the youth of the US. Do the doggos not worry about thunder? My doggos do not actually give a shit about thunder and lightning. They are very chill. They will be entirely chill. So harms from gambling addiction can be much more extreme. Common conceptual framework for these harms, the Langham framework, groups them into 7 categories: financial harm, relationship disruption, psychological distress, decrements to health, cultural harm, reduced performance of work or study, and criminal activity. So I end up dealing a lot with gambling addicts because gambling addicts are really common for like embezzlement or theft from work or the like. And so you'll find that these people will have embezzled like millions of dollars and they have nothing. Like they will have embezzled, like $4 million from their company. And when the police do a raid and they take pictures of the inside of this person's house, what they see is like the person has a mattress and that's it. Like everything gets sold. I had a client who, when the police were in the guy's house, it was clear that he was cooking cans of beans and shit off a candle because he'd sold his stove to get more money to gamble and literally just had a candle on a little metal rack and, would put the can of beans above the candle and would light the, would light the candle to heat the beans. And that's how this guy was living. And I mean, I'm sorry, if I stole millions of dollars, I would like to think that I would be living in some kind of luxury, that I'd be living like a millionaire. And instead, these people are living these hollowed out lives. Everything in their life has been sold. And it's really, really awful. So, yeah. You could cook with stove, except they sold this. Yeah. They sold the stove, right? So, yeah. As a result of the potential harms associated with gambling, experts have opined that where a platform involves financial stakes, uncertain outcomes, and repeated participation, it is critical to assess the public health implications and ensure appropriate protections are in place. This also is why this is also why I am very careful to, with gambling myself. I went to a casino at one point and I was like, I'm going to try playing, some sort of gambling game. And so, I went and I think I took $300 out in chips. And I took my $300 out and I wandered the casino and I was like, I'm going to play something. And I couldn't find a table where anybody looked like they were having fun. You go to the poker tables, people look like they're fucking miserable. You go to the blackjack tables, people look like somebody just died. You go to the roulette tables, people look like they're, a bunch of zombies who just hate everything. And so I ended up walking back to the cashier with my $300 in chips and being like, I would like to cash these in. They're like, didn't you just get these out? And I'm like, yeah, this place is depressing as fuck. And the cashier's like, well, you're doing better than most of the people here. So here's your money back. And, yeah. It also helps that I have no luck. I went to, while I was in Vegas at one point, a friend of mine was playing blackjack and spotted me money so that I would be there to, provide them with some company. And I know the optimal strategy for blackjack, when to hit, when not to hit. And I was just like every hand I would lose, like every hand. And to the point where like the guy I was hanging out with was just like, dude. And I'm like, I know. So that also helps. So 11% of individuals 55% and older placed a bet before the age of 21, whereas 33% of 21 to 44-year-olds did so. College-age consumers can be significantly affected due to less developed risk evaluation and impulse control. They also tend to exhibit sensation-seeking behaviors, keen interest in novel experiences, and less mature emotional regulation skills. It is thus unsurprising that gambling addictions affect college-age individuals at a greater rate than the U.S. adult population. For example, a 2014 meta-analysis estimated that about 10% of college students have a gambling problem, compared with 2 to 5% of the people generally. Whew. Basically, they have a whole bunch of stuff here saying they are seeking to suck money out of the college-age U.S. market. So law violations. They've violated the CPPA by representing the goods and services have characteristics that they do not have, representing that the goods or services of a particular standard, quality, grade, style, or model, if in fact they're of another, misrepresenting as to a material fact, that which has a tendency to mislead, failing to state a material fact if such failure tends to mislead, using innuendo and ambiguity as to a material fact which has a tendency to mislead, advertising goods or services without the intent to sell them as advertised, and otherwise engaging in an unfair or deceptive trade practice. So count 1, deceptive marketing. So basically what they said before. Count 2, deceptive failure to disclose material connection. They've got influencers who are influencing to promote this, but not actually, not actually advising people that they've been paid to promote it. Unfair promotion of the Polymarket platforms to college-age Americans. So pushing this on kids. Consumer injury. They're saying people have suffered losses and defendants have been unjustly enriched as a result of it. Remedy. They want a permanent injunction against defendants' use of the unlawful trade practices described herein and its reasonable attorney's fees and costs of suit. They also want equitable relief, including equitable restitution, disgorgement of profits. Did you hear how the profits were billions of dollars? And they want disgorgement of profits. This could be big. Prayer for relief. They want the following relief: a declaratory judgment, equitable relief, including disgorgement of all profits and money unlawfully obtained, and financial restitution to all harmed consumers in DC, attorney's fees and costs of suit, permanent injunction, and such legal and other equitable relief. I would be stunned. It'll be fun if they get the billions of dollars that they're asking for. That's a huge. So I'm going to follow this one. I think it's real interesting. On the replay, but happy to catch you live. Love you, Runkle. You're really one of the good ones. Thank you. man, I want to make that announcement. I really want to have the announcement. I can't make it yet. I was told I could probably make the announcement. Soon. I'm really excited. And I may just have to set up a celebration stream. And you guys had come out for just a celebration stream where it's like, I've got a big announcement. Something cool is happening. Let's sit around and like drink wine and, you know, whatever. So that might be the plan, because I might not have anything else to talk about when it lands. Somebody says, how about tomorrow? Tomorrow is date night. And I try to protect date night because so like one of the things about I've done this speech a few times, and the speech is basically that I've been invited to talk at different people's weddings a few times. I've been invited to officiate weddings a couple of times. And so one, like when I've been invited to talk, one of the things I say is that you know, a relationship and like love isn't something that just happens to you. It's not something like, you know, Disney movies, you just meet the perfect person and, you know, you fall in love and everything is perfect, right? And the thing is that that's not really what happens. You meet a good person, but nobody's perfect. No, like I'm not perfect. Mrs. Runkle is really close, but you know, there's some things she does that annoys me. She leaves time on the microwave, and I was like, could you stop leaving time on the microwave? And she's like, nah, that's probably not going to happen. I'm like, all right, fair. Like fair. I get it. Like that, you know, because at the end of the day, I'm not that upset about the microwave, right? It's just like, all right, it fair. Like if that's then we're just you know, I'm just gonna live with it. What is it? Does she leave the light on in rooms and then walk out? No, that's me. That's my thing. So the thing is you you've got to actually work on relationships, because if you don't, you know, a good relationship is like an old car. It's going to take maintenance. It's going to take work. And it might be a really awesome car. It might be amazing, but you really like, you got to put work in, and the work is worth it. And it doesn't, you know, but you got to do things. And what I was finding is that I was so like between the job and the YouTube and other stuff, I wasn't paying enough attention. I wasn't paying enough time. I wasn't reserving enough time for Mrs. Runkle. And so I was like, all right, I got to do something about this. And I was like, we're setting aside Tuesdays. Like we are just doing that. And so sometimes we can't, right? Sometimes we have, you know, there'll be a massive thing that drops and it's like, I got to do it. Or I'll be covering a case and it's like, I got to cover the Tuesday. Like it just is what it is. But I try to protect it as much as possible now, because it, you know, it is important. It is worth it. It is, so if the big news happens tomorrow, we can celebrate Wednesday. That's just how this is going to go. That's how this is going to go down, folks. So yeah, that's just things. Let's see what else. All right, I guess super chats. Steve A says Mrs. Runkle earns date night for loaning you to us. I am so lucky, like just so amazingly lucky. Jessica Carlson, thanks for making Mondays better. Thank you. Gerald Manning, thank you so much. And Michigan Farm Boy, a couple of things. Have you heard Corb Lund's The Truck Got Stuck? I have not. Institute for Justice does public interest lawsuits pro bono. Awesome. Several cases have gone to SCOTUS and won. Think you'd like them? I think I would. Gerald Manning, thank you. And thank you. And thank you. And thank you. That's very generous. I feel like there's a goal you were hammering there. Oh yes, story time. Witnessed a lawyer's bad day. I will have to tell you that story because yes. Dr. Purple Dragonair, whenever I need to gamble, I bet on the horses. Horse racing is very misunderstood since the majority of people love the animals, and I'm much more willing to try my chances there. The only time I ever bet on a horse, the horse died. Like, yeah, that was not good. I bet on a horse. The horse like crashed in a way where it was like the crash was seriously injured and or the horse was seriously injured, and it's like, that's not an injury that the horse is going to survive. So like, broken legs and all of that. And I was like, all right, my luck for gambling is so bad that like I am not going to bet on anything alive because it's just like, yeah. Yeah, I went in, I like basically put $50 on this horse and like $50 to win. I was like, all right, if this horse wins, it's going to pay back however much. And the horse just like bad. It was really, really awful. So yeah. What is it? As in most gambling, if you can't tell who the sucker is, that means it's probably you. Yep. Gambling disorder is the only behavioral addiction listed in the DSM-5. Thank you, Runkle and Pups. Yep. Andal Feinstein, thanks to you, we have our own date night. It's Wednesday. Some weeks we have to move it, but we make sure it happens once a week. Sometimes I have to cancel. Sometimes she has to cancel, but we try to keep it sacred. Now I want to see Runkle open a pack of like Pokemon cards or something. Maybe I'll do like some magic card openings or something. So, yeah. Any significance to you doing a Janet story? Any resolution in your case? The case is still ongoing. Future trips planned / scheduled. Also, cam phasers weren't a cheap fix on my F-150. It's not the cam phasers. It's the cam phaser transducers, apparently. And celebrate with Mrs. Runkle first, always. Yes. All right. So I owe you guys a story of watching a lawyer have a very, very bad day. And so I don't know the full background, but this lawyer was in front of a judge, and this judge is a very good judge. However, this judge, I always got the sense the judge did not like me very much. And the reason why I say that is because, so I had a boss. This boss sent me to run a trial at the last minute where I'd never seen the file. And so I went in and I bombed this fucking trial because I'd never seen the file. I was an articling student, and the guy's like, go run this trial. And the judge was super, like, he was doing the, like, I am disappointed thing. And it was reasonable, right? Because I was like, I had no fucking idea what I was doing. And so the judge was just like, so anyway, I think this judge has always kind of been like, I made a bad first impression. It wasn't really my fault, although, it's always your fault. So, Anyway, this judge, Judge Anderson, he's been a judge since a long time. But before he was a judge, he was a defense lawyer. Oh no, my boss is no longer a lawyer. He got disbarred. So that guy got disbarred. But before this judge was a judge, he was a defense lawyer, and he was a really, really good defense lawyer. Like really, he was one of the people that you call if you have like an unlimited budget and you are being charged with murder, that kind of defense lawyer, right? And it's easy to forget that the judge has been a defense lawyer and has all of this experience if you haven't seen them doing that, in your entire career. So this lawyer was bullshitting about the judge is Judge Anderson. Great judge. I have tremendous respect for the guy. Great judge. But this lawyer was there bullshitting about what days he did certain things. And the lawyer was, I think I might have said the judge was, the lawyer was bullshitting. And so this judge just starts asking him questions, very friendly questions. And the thing is, if you know defense lawyers, when you're getting asked friendly questions, you might be getting set up for the difficult questions later. And so the judge is asking him, and the thing is, this is just a docket appearance. He's just there. Normally a docket appearance, this is how a docket appearance goes. Good morning, Your Honor. Runkle, first initial I. I'm here on the matter of Bobson. It's on page 6. It's number 12. And you wait for the clerk. The clerk is like, I have the file, Your Honor. And the judge says, okay, what are we doing on this file? Your Honor, we're still waiting for disclosure on this file. We just requested it. I've just been retained on this file. I'm asking for 3 weeks so that I can, so that I can get the disclosure, get up to speed, and then determine what we're doing. And the judge says, okay, cool. Over 3 weeks. That's it. That's like an entire docket appearance, right? Docket court. This guy was being asked question after question after question. And he was being asked questions for like 45 minutes. And he's like, Your Honor, if I could just go. And the judge is like, nope. You are not excused, and just keeps asking him questions. And at first, I'm sitting there and I'm like, man, the judge is just real inquisitive about this file. And then I'm like, oh shit, this guy doesn't realize he's being cross-examined, because I'm seeing that the judge is laying all of these details out. And I'm like, oh shit, this guy is being cross-examined. And finally, the judge, once he's got everything, is like, so you said that you did this step on this day. And the guy's like, yes. And the judge is like, I'm just going to turn to the transcript from that day. And I'm like, oh, fuck. Oh, fuck. Because the judge is sitting there with all the transcripts of every appearance this guy has made on the file. And I'm like, oh shit. It would not have made me go, oh fuck, the way I did if the judge had just pulled a gun and set it on the bench. Because, like, put it this way, to get the transcripts, we don't just generate transcripts for every appearance, right? Things get recorded, but there's not a transcript. In order to get the transcript, the judge would have had to specifically request those transcripts. Plus, the judge clearly reviewed all of those transcripts. And now he's saying things like, well, on this day, you said this. And the guy's like, Your Honor, I don't have the transcript. And the judge is like, do you think I'm bullshitting you, sir? Or do you think that is what you said? And he's like, I'm sure that's what I said, Your Honor, if it's in the transcript. Oh, and yeah, it was planned ahead. It was like the judge was fucking pissed and set this up. And so this guy is now and the judge is like hitting him with transcript quote after transcript quote, and is just dismantling every little like deception and weaseling and so forth, and is just taking this guy down. And finally, the judge is like, very little of what you said today in court was true, wasn't it? And the guy's like, yeah. And the guy's like, Your Honor, I would like to make an application to get off record. Which means he's like, I just want to get off the file. I just like, please let me off the file. You know what the judge says? Denied. I am denying your application to get off record. You remain on record. We are going to have another appearance, and it will be set in accordance with my schedule. I am free on this day. Do you have a trial on that day? Well, Your Honor, I have other commitments. Are they trials? No. Are you subpoenaed for those days? No. He's like, then you can find somebody to make your other appearances. You will attend on this day. I am directing that you advise your client to show up on that day. On that day, I will entertain your application to get off record. I am also directing that the transcript for today be ordered. And I am directing that it be sent to the Law Society of Alberta. And he's like, sir, I advise that you have approximately 30 days before that transcript is prepared. You should use those 30 days to report yourself to the Law Society. Because, and I was like, oh, man. So watching the judge just dismantle that guy was like, I never want to be him. Never want to be him. And yeah, I just now here, you want to know the worst part? It's not really the worst part, but it's like a bad part. Normally in court, you run things in order of seniority, which means that the most senior lawyers get to go before junior lawyers. And I was a fairly junior lawyer at the time. After the judge finished ripping that other guy to shreds, he's like, okay, who's up next? And the senior lawyers in the room are like, I believe Mr. Runkle has a quick matter. And I'm like, you fucks. Not going to name them, but I remember them because they were like, why don't you go up? And I'm like, hi. And he's like, Mr. Runkle. And I'm like, yes, Your Honor, I'm on this matter and I would like an adjournment. And he's like, done. I'm like, thank fuck, because oh my God. The judge didn't give me any shit. The judge was like perfectly reasonable. perfectly nice. And I was just like, oh my God, am I about to get like, I was like, you cowards. So yeah, I mean, I've had some moments with judges, because I mean, you get moments where judges are, in a mood or snarky. There was one judge who she did not like that I was the student of my boss, and so she would hold me to a very high standard. And it was because she thought my boss was a shithead. Well, she knew that he was a shithead, so she knew before I knew. And so she was like very much holding me to strict standards up until eventually she's like, Mr. Runkle, I know I've been treating you. So the judge was like, or this judge, she's stern, but she's very fair. Like one of the fairest judges I've ever encountered. And smart. Fuck, she's smart. Like dangerously smart when you're in front of her, because she can spot bullshit like nobody else. So I'm there and I'm in front of her, and she was like, Mr. Runkle, can you stay a moment? And I'm like, fuck. I was duty counsel, and so we were wrapping up for the day, and she's like, Mr. Runkle, I'd like you to stay. And I'm like, oh shit. So we're staying, like I'm sticking around, and she's like, Madam Clerk, we're off record, right? And the judge is like, or the clerk is like, yes, recording's off. She's like, Madam Clerk, we don't need you anymore. And the clerk is like, okay, and leaves. And she's like, Mr. Runkle, you will have noticed that I have been particularly strict on you these past, however months. And I'm like, Your Honor, I had not noticed. And because she's got a sense of humor as well, she says, Mr. Runkle, I remind you that you have a duty of candor to this court. I'm like, damn, that's funny. Because she knows that I'm being nice. And, so I'm like, okay, fine. I have noticed that you've been particularly strict. And she's like, Mr. Runkle, I just want you to know that I was being particularly strict because I wanted to make sure that you did not fall into the pattern of your principal. And I was like, okay. And she's like, Mr. Runkle, everything I've seen has suggested that you are a diligent and ethical lawyer. And so I am going to relax a little bit and I was like, thank you, Your Honor. And she's like, but don't think that means you can get away with anything in my court. And I'm like, understood. She's like, thank you, Mr. Runkle. That's all. And a pleasure having you in my court as always. And I was like, thank you. And I got the hell out of there. So basically it was just like, your boss is a shit. I was being extra harsh on you because I was worried you might turn into a shit too. You don't appear to be a piece of shit, so I'm gonna ease up on you. She is a fantastic judge, just absolutely fantastic. She's one of the judges that I've seen change her mind in real time. Because often by the time you're getting to closing arguments, the judge is pretty much decided. And you can argue your best, but you don't often see the judge change their mind in closing arguments. So I had this closing argument, and she was grilling me. And she's like, Mr. Runkle, you are, like, how does this make sense? And I was like, and so what I ended up arguing, and I mean, I think I was correct, and she ultimately agreed. I said, Your Honor, you're asking the wrong side. She's like, how do we know this witness is lying when there was inconsistencies? how do we know they're lying? How do we know they're wrong? And I said, Your Honor, you're asking a great question, but you're asking really the wrong side. Because fundamentally, if you're asking, how do we know they're lying? The question we should be asking is, how do we know they're telling the truth? And you should be asking that of the other side. Because my client has, he doesn't have the burden. The burden of proof beyond a reasonable doubt is on the prosecution. And all this is doubt. We have doubt as to whether they're truthful. I'm never going to be able to prove to you to a certainty that this witness is lying. But it certainly seems like it. There's certainly indicators. There's indicia of lying. And so long as we have those indicia of lying, you need to ask my friend, the prosecutor, how do we know this person is telling the truth? And I see her lean back in her chair and go, And she says, Mr. Runkle, I might come back to you. And then she turns over to the prosecutor and says, Mr. Runkle has a good point. How do we know this witness is telling the truth? And the prosecutor goes, and says, well, and, starts arguing. And at the end of it, she says, okay. Ultimately, I do not have, I'm not in a position to determine that this witness is truthful. And therefore, I have reasonable doubt, and I must acquit. It was not an SA case. It was an allegation of low-level domestic violence and breach of conditions, if I recall correctly. So, it was a weird case, but not an SA case. I don't much care for SA cases overall. I've run them, but I don't like running them. So, hiccups. All right, Gerald Manning, have you thought about having an Extra Life banner pop up? I think it'll be cool. I should figure that out. I should try to work that. But yes, that's a good idea. If Runkle ever announces he's getting divorced because of us, I will cry so dang hard because I was following Rob's girl and she went off the rail. I don't know what that's about. Rob and his girl are doing great. So leaving out the Rob stuff, because Rob, I think he's doing great. What is it? If I ever get divorced, I don't want to get divorced, it'll be my fault. It's not going to be your fault. That'll be my fault. And it's like, if I fail to set boundaries, that's my fault. So yeah. Slovak girl, thank you so much. Much appreciated. So yeah. Different Rob, maybe. Because I don't know how that makes sense with Rob, or at least unless it's a different Rob. But yeah. It is now 11, which means Mrs. Runkle is going to be asleep. I'm going to go see if the Leatherwork shop is... I can't find my mic for actually doing Leatherwork streams. It's somewhere. I don't know. I think I packed it and then... But what is it? I might go see if I can actually just do some Leatherwork, because it is... I'm going to see if it's cool enough to do some leather work. The garage might be stupid hot. I just got to go see. If it's too hot, I'm not going to, we're not going to. But, Anyway, thank you guys all for joining me. It's been a lot of fun. And, we'll see you guys next time. Good night, all.